You have something?
I'm not Rodney Miller.
Rodney Miller, okay. Commonwealth, Kentucky versus Rodney Miller. Rodney Miller here. Do what?
It's $5,000 cash bond. I've already got an NCI.
And my contact, or my client contacted me on Saturday saying he had COVID, but he's not presenting any proof to me.
Would you, well, I do a deal with you if you want to take his place and we'll hold you till he shows up, or you don't think that's a good deal?
No.
Well, I just thought I'd offer, you know, I'm always very courteous, as Mr. Bell said to out-of-town lawyer. Okay, well, we'll leave the warrant out. Would you like to be excused from your representation here?
Yes, sure.
Okay, you appeared and he didn't, and you just send me an order at some juncture, you know, that you were relieved. Okay, thank you very much.
All right, thank you.
Yeah.
That's all I have.
You have a great day. Well, we can just leave it hanging out there. Who put the bond up? It's gone, man. Submit me an order. Okay. Now, before, come on up, brother. Yeah, I'm doing, this is an in-person document. Would you like to come up? Would you like your person? Who do you represent?
I represent Christine Charles
What's the last name?
Brown.
Brown, okay.
And,
Well, if he's not in person here, is Christy Brown here?
she is.
You want to come around, Christy Brown? Now, I guess looks like a Dare County jail is online. What's Mr. Brown's first name? Charles Brown. Y'all have Charles Brown there yet? Okay, what do you want to do with this case? That would be for March 31st. Do you have a negotiation date, man? Okay, if you contact Commonwealth attorney directly for a negotiation date. And well, we can go to April 28th, but that means that your client has to stay incarcerated for another month. Great, April 28th. Now, if you reach some plea agreement before then, I'd be glad to take a plea in another county to expedite the thing for both of you, okay? If we don't, we'll set a trial. If you see you're not going to negotiate it, there's no reason to wait till next rule day, Mr. Stockton. We can go ahead and set a trial date because, you know, these are serious charges and he might be in for a while if we don't set a trial date. Okay? Thank you very much. Yes, absolutely. Mr. Bell, you got a couple?
Yes, sir. Michael Gross.
Michael Gross. Oh, Mr. Gross. Commonwealth, Kentucky versus Michael Gross, 21 CR 00154. We're here on the pretrial conference.
We have a resolution now, pre-trial.
You have agreed, the papers filled out?
Yes, sir.
Okay, wait just a second here. Your name is Michael Gross. motion's been tendered that says you wish to enter a plea. Is that correct?
Yeah.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yeah.
Are you the same person named in indictment number 21 CR 00154?
Yeah.
Have you discussed this matter with your attorney? Are you satisfied with it, with his advice?
Yeah.
Believe you had an opportunity to review all the evidence they have against you? Okay, you have certain rights under the Kentucky and United States. Under the Kentucky United States Constitution, no one can make you testify against yourself. No one can deny you a speedy trial. You have a right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you. You have a right to produce evidence, a right to call witnesses in favor, a right to appeal this matter to higher court if you lose, and a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. You understand, but entering this plea agreement that you give up some of those rights. Now, in the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, I will allow you to withdraw your plea if you don't agree with a harsher sentence. Have you been previously diverted in the last 5 years? Do you have any felonies in the past 10 years? Any felonies in the last 10 years?
No.
Are you on probation or pretrial diversion?
No.
Okay, Mr. Stockton, you want to announce what you got going on? If y'all step to your left there just a little bit.
Honor, Mr. Travis is found guilty of possession of controlled substance first degree. He received a sentence of 3 years, pretrial diversion, 3 years. This is supervised. It exists for the SSC, follow all recommendations. All evidence in this case will be destroyed.
Is that what you agreed to?
Yep.
Okay. You understand that if you successfully complete this pretrial diversion, the case will be dismissed pretrial diversion and you can get the same expunged. Now, has anyone, including your attorney, offered any other recommendation or benefit of the plea, or have you been threatened and coerced?
No.
Okay, you're pleading guilty because you are guilty of and you're pleading your own free will. Knowing what I've explained to you about your constitutional right, do you waive them and enter this agreement? Is that your signature on the document there?
Yeah.
Okay, I'm going to accept the pretrial diversion agreement. I will enter it. You'll need to meet with probation and parole officer over that.
$210.
Okay, your court costs are $210. Do you want to pay that today or do you need some time? Well, I'll give you some time if you want to. Okay, I'll let you pay $70 today, and then $70 every 30 days. That'll spread it out a little bit. Okay. Okay, meet with the probation and parole officer. You get the information. Mr. Bailiff, you want to bring the documents up here? Okay, we'll be real careful on this thing, okay?
Is that Franklin?
Franklin?
Yes, sir.
Commonwealth versus Brandy Lorraine Franklin, 21 CR 00119. We're here for pre-trial conference.
Ron, we only got the letter that goes back. I think she was down there. We're gonna do it. No, February 11th.
You want her there on that day? You'll be at Monroe County on February the 11th. Could you pass a drug test if I gave you one today? I didn't think so. Come with him here. What do you got in? Do what? Meth? Okay. I don't know. I don't know what I'm gonna do with it. You know what I mean? I've known you since you were a baby. I watch your little girl play basketball. You know, watch your mama there, proud of her and stuff. Instead of doing that, you want to go down this road.
Anyway, put it on an ankle monitor on strict home incarceration judge and her go to U-turn or some kind of IOP so we can get this resolved.
So Okay, who else? Anybody else got anybody here that's in the courtroom? Are they in the courtroom here? Okay. Who? Amanda Reynolds. Oh. Wait just a second. I'm trying to find it. Commonwealth, Kentucky versus Amanda K. Reynolds, 21 CR 0094. Are you Amanda Reynolds? Born in 1980. Last four digits, social security number 4429. Here for a pretrial conference. What you got, Mr. Cross?
Your Honor, I believe the matter is filed or briefed on this page.
This is the search. I read it this morning. I think the search is good. I'll give you the reasons why I do. So if you want to proceed with something else. Okay. Okay. Okay, I'll give you written findings on it. Well, I'll give you plenty of time. I won't file it like that morning like some people do. And then the next appearance will be the 24th. The conference on the 11th and then the 24th. It brought up some interesting situations as far as it is peculiar set of it was interesting. How much you have to inquire as to who owns the property, who has possession, that sort of stuff, you know. Okay, who's your next one?
Andrea Anderson.
Commonwealth, Kentucky versus Andrea Anderson, 21 CR 008 and 21 CR 00115. What do you have to say?
That's correct.
Okay. What were the facts in this case? See if it'll jog me.
Your Honor, there were two cases on this after. One is the extenuation of a stop,
Yeah.
and the other one is where they went in on a home that she was renting, and her father answered the door, they came in.
And then you also said that that went beyond the scope of the permission too, right?
Yes,
Is this one where they had the sniff of the marijuana?
one of them was yes.
Yeah.
And another one where her father opened the door, he was also in the place to live in, yet they were into it.
Yeah. Okay, well, you just go ahead and schedule this one for a negotiation on the 11th and the pretrial on 24th. And I'll give you written findings on it.
All right, you're up.
Second. Commonwealth versus Stacy Shelley, 21 CR 00156. Are you Stacy Shelley? Were you born in 1981? What are the last four digits of your social security number? The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance, first offense, possession of marijuana, possession of open alcohol beverage container, and having one headlight. You acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, and plead not guilty, reserving all pretrial motions.
Yes, Your Honor.
Set this for negotiations on the 11th of February. What kind of motion are you gonna have?
Stipulate the stop, but it depends on the time of day, what headlight.
Well, Mr. Cross, with all due respect, the motions that you file, I'll hear, but they just, all of them are the same, it appears. Most of them, they just say this is unconstitutional search. So if you go ahead and file those motions, if you get them to me in a timely manner before the 11th, I can enter an order. And if you might just not have to go. But I don't want to wait to the next rule day and then say we don't have a negotiation. So
I might ask how the court enter an order.
I didn't say I was going to enter the order. No, I said, I'll take a look at it and see if I can tell anything about it. I'll tell you, if you give me enough detail in it, that we might decide whether we need a hearing.
Your Honor, it's all with respect to the court, this court on pre-verification practice is we don't know what the proof will be in that period. All we know is citation and discovery as far as the sequence of events and what an officer will testify to. That's what we see.
Well, I mean, we have the pleadings that are required in Kentucky are very broad. You don't have to have particularity, but you don't know what the Commonwealth might offer you. Your client knows what situation she was or wasn't in. I think negotiation can still be helpful if they made a deal of the century, but if you don't want one, that's fine. We'll have her back here on February the 24th. And if you have any motions to file, I want them filed by that date. Okay, thank you. I have a reciprocal discovery order, ma'am, that is going to give what the Commonwealth has to your attorney. I already handed it to him, okay? Thank you. Okay, does anybody else have anybody? Yes. Annie Alexander. You venturing over here pretty far, aren't you? Yeah. Wait a second, I found it. Commonwealth versus Annie L. Alexander, 21 CR 00144. Are you Annie Alexander, born in 1991? Last four digits, social security number 6516. What do you got going on?
I think the Commonwealth is agreement for a new negotiation conference.
Your Honor, there's 4 defendants in this case. They all have attorneys now, so I would like to make a motion.
Okay, and then the next appearance in court will be February 24th, okay? Bruce Cole. Bruce Cole. Hello. This is Commonwealth Kentucky versus Bruce Cole, 21 CR 00112. You are Bruce Cole, is that correct? Pull your mask up over your nose there, Mr. Cole. Thank you so much. You're born in 1979. Last four digits, social security number 9267. You're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole? Okay, that'd be fine. Christopher Cooksey. Commonwealth Kentucky versus Christopher Cooksey, 21 CR 00151. Are you Christopher Lee Cooksey?
Yes.
Born in 1973.
Yes.
Last four digits, social security number 6319. Okay. Here today for pre-trial conference. What do you have?
Your Honor, we have a restitution order to tender to the court. Mr. Stockton and I have been discussing this case. And Mr. Cooksey is going to have all of his restitution paid by the 24th of next month. He has half to pay now. And I think at that point, if he follows through, Mr. Stockton was looking at possibly dismissing this case.
That's correct.
Okay. When do you want him to come back for review?
Well, I get.
Okay, if you'd be back here on February 24th. Okay, thank you. Marie Hagan. Commonwealth, Kentucky versus Marie Hagan, 21 CR 0091. Are you Marie Hagan?
Yes.
Born in 1976. Last four digits, social security number 1772. What do you have in this case?
We have a plea agreement. I'm forgotten to get Mr. Stockton to sign it.
Well, that's always helpful.
Yes, Your Honor. It's a diversion agreement.
Okay. Ms. Hagan, I understand that you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes.
State your full name, please.
Marie, you know,
Is your judgment impaired today anyway?
no,
Okay. Have you discussed this matter with your attorney? You feel like you're fully informed? Okay, you have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Your right to speedy trial by jury, your right to be represented by counsel at your jury trial, your right to confront and cross-examine all witnesses, call testify against you, your right to produce evidence, your right to call witnesses in your favor, your right to appeal this matter at higher court if you lose, your right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty. By entering your guilty plea today, you have those rights. Now, I may consider the Commonwealth's recommendation, or I can give you a harsher penalty under the law. If I give you a harsher penalty, however, I'll give you an opportunity to withdraw your plea. Now, pretrial diversion, if successfully completed, means that the case can be dismissed pretrial diversion. However, if you violate the terms of pretrial diversion, I can call you if you have a pre-sentence investigation report out of probation and parole. The sentence should be a convicted felon. This could be used against you in the future. You understand that? If you violate the terms of your pretrial diversion, and I call you back up here and revoke your pretrial diversion, then you will be a convicted felon. And then it can be used against you if you do that. However, if you complete the terms of pretrial diversion, the case will be dismissed, pretrial diverted, and you can get it expunged from your record. Okay. Now I've got a few other questions. I need to ask you, are you presently under probation? Are you presently under probation?
no,
Have you had a felony conviction in the last 10 years? Have you done a pretrial diversion in the last 5 years?
no.
Okay. You want to come up with your recommendation, Mr. Stockton?
The assault second will be admitted to one and second first 5 years. Sentence will be imposed for the first 30 days, balance pretrial diversion 5 years, diversion will be supervised. You'll have no contact with the victim, pay court costs, maintain gainful employment, and this is in accordance with the record.
Is that what you agreed to? Are you doing this because you are guilty and for no other reason? Okay, is that your signature on the document? Okay. I will agree to the pretrial diversion. Okay, you need to meet with probation parole officer there so we can get some information about you, okay?
30 days, so I don't know if we're going to turn it today or.
Yes, but she needs to meet with him first, then she's in custody.
Sorry, one more question. What rate did you take?
$30 a month on her release, okay? Dallas Hayes. Commonwealth of Kentucky versus Dallas Hayes, 21 CR 00145. Are you Dallas Hayes? Okay.
Yeah, an agreement, Your Honor.
You born in 1990? Last four digits, social security number 8662. I understand that you wish to enter a plea today. Is that correct? Is this a felony plea?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Are you the same person named in indictment 21 CR 00145? Are you satisfied with the advice of your attorney? You've had plenty of time to discuss this matter with her. I didn't ask you that. You answered the questions I'm asking. Okay. And are you telling me you don't want to enter a plea today? Okay. Have you had plenty of time to discuss this matter with your attorney? And are you satisfied with her advice? You reviewed the case Commonwealth has against you and you're familiar with all the facts. You understand that you have certain rights under the Kentucky and United States Constitution. You do not have to enter a plea today. I have to know you understand those rights before I can accept a plea. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witness in your favor, right to appeal this matter to a higher court if you lose, and right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. You understand that by entering a plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. Prior to accepting your recommendation, I'll await the pre-sentence investigation report to be done for probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw the plea. Now, take a left there. What's the Commonwealth's recommendation?
Sure, ready. It was a valid question. Connor, not plea guilty to possession of controlled substance first degree, 2 counts. Defendant shall receive a sentence of 1 year on each count to run currently for a total of 1 year to serve. Commonwealth announced that at this point that we oppose probation and will oppose.
Is that your understanding? Come back up here. Does anybody threaten or coerce you in any way or make you any other promises? Knowing your constitutional rights, I've explained to you, is it still your desire to give up the rights, enter a plea? Do you understand that in the future, if you have another felony conviction, this could be used against you under persistent felony offender law? You understand that? Is that your signature? Okay, I'll accept the plea order, pre-sentence investigation report done by probation, parole, and schedule of sentencing for the 24th. Now, if he's got this time to serve, is that correct? Okay, you're in the custody of the jail. You meet with probation and parole officer first. Have him step over there and give information to probation parole officer. Is it hard? Noah Neal. Commonwealth, Kentucky versus Noah Neal, 21 CR 00143. Are you Noah Neal? You're here for pretrial conference.
We are, Mr. Neal's one of the defendants. I think Mr. Stockton talked the other day, and then I objection to that. We negotiated last week. I think.
February the 11th at 1 o'clock and back here on February 24th. Okay, both of them are conditional bond. Michael Nethery. They had him, they don't have him. We didn't have him. This is docket for in person. Okay, well, I'll try to see if we get him on the jail docket. If he's on the Adair County, he's in Adair County.
No, Your Honor, he's out of custody. I haven't talked to him, Your Honor. I believe he called the clerk.
Is there a warrant out for him? Okay, well, I'm gonna leave the warrant out for him. And there's no reason for anybody to call me about a bond on him. It's to be held without bond. Who's on his, was he out on bond or? Okay, so he went, I know, but when he absconded, was there a bond? He was in drug rehab by then. Okay, I understand that. Okay, thank you. Jared Norris.
Nine I was on her, so it ain't bad. That's him. And probably a couple of our
As they
pre-trial.
say, Mr. Stockton, a word to the wise is sufficient. And if anyone is watching this broadcast that knows Mr. Michael Nethery, it would be possible that if the Commonwealth wanted to, they could prosecute for escape, couldn't it? Yeah, I mean, be good to go ahead and put this behind you. Just saying. Jared Norris. Good morning. This is 20 CR 009. Mr. Norris, you born in 1986.
Yes, sir.
Last four digits,
Oh,
social security
second.
number 8168. Okay. March 31st. You don't have a negotiation day in March. Ms. Costello will know it's your responsibility to get in contact with Mr. Norris, and he's required to attend that negotiation day as well as the rule day on March 31st, okay? Thank you. Ashley Stotts. Ashley Stotts. Hello, Commonwealth versus Ashley Stotts, 21 CR 00150. You are Ashley Stotts. This was a direct submission case. Do you have an attorney?
No, I was just picked up by a president of warrant. He picked me up. I know not, no knowledge. He said he had no knowledge of the case either. I never received a letter.
Well, I'm just asking you if you have an attorney. Are you gonna get a, well, I'm gonna take care of that for you. Just calm down. We'll make it through this. You know, your goals should be to leave here today.
Yeah, I have a letter.
I don't want to talk to you about the case. I can't. Okay, I'm just trying to arraign you. Okay, Ms. Perigin, will you stand in for arraignment? Just stand up here. Ms. Perigin is an attorney. She's just going to stand with you during this arraignment here, and then I'll relieve her of that. Now, are you going to hire a private attorney, or are you going to get, do you have money to hire a private attorney?
Either that or they sent me some options to the state that I can check into for the new services and whatnot.
Okay, well, I'll just arraign you today then. This is 21 CR 00150. You are Ashley Stotts. What are the last four digits of social security number?
It's 8519,
What year were you born?
84.
The grand jury of Cumberland County has returned an indictment charging you with false or fraudulent statements to obtain assistance. You have a right to remain silent. You serve that, hand that to Ms. Perigin, please. Ms. Perigin, you acknowledge the identity of your client, receipt of the indictment, waive formal reading and arraignment, enter a plea of not guilty on behalf of Ms. Stotts. You do that? Okay. And Ms. Stotts, I'm going to schedule you to be back on February the 11th with an attorney here to meet with Mr. Stockton, and back in court here on February the 24th. Okay. If you want to give her a copy of that, just give her a copy of the indictment there. Now, what about the discovery? You want to hold the discovery? So when you get an attorney, you notify the Commonwealth Attorney's Office. They'll give you a phone number, and that'll be okay. And Ms. Perigin, you're relieved of any further obligation. Okay. Timothy Ray. Is Timothy Ray here? Now, the surety on the bond is who? Ms. Ray, you cannot get off the bond until he's in custody. That's the purpose of a bond. See, if he doesn't show up, your bond could be revoked. So we can't, if we allow people off bonds when somebody doesn't show up, everybody went off the bond. You understand? Well, sure. Huh?
So I'm questioning. I want to talk, but I don't want to be responsible for $15,000.
Well, you signed it, didn't you? So you are responsible until he's back in custody. That's the purpose of a bond. So if you want off the bond, you get him back into custody, have him to come and turn himself in, and then I'll let you off the bond.
That's why I'm on the bond.
You haven't gone off the bond. You're on the bond.
I signed papers to go off.
What do you think the purpose of a bond is?
Well, they told me when I signed it, if you do not abide by what the rules were, for me to come and sign the paperwork to get off the bond.
Well, who told you that?
The people in the Dare County Jail.
Well, they told you the wrong thing. If they told you, well, I'm sorry, the bond is that you're responsible to making sure that he appears. And when you sign the bond, if he doesn't appear, you're stuck. So if you have any way to contact him, you need to tell him to come in, because the Commonwealth can move to revoke the bond and collect $15,000 from him. Is that right, Mr. Stockton?
They let me find, you issue a warrant, you do what you want. I don't want to call it. I don't want to be responsible.
But you are
I
responsible.
understand that.
Okay. Okay. Well, thank you.
But I'm responsible.
Yeah.
I understand.
Okay.
I don't want to be responsible for $15,000. He didn't do what he promised.
He didn't what?
He didn't do what he promised.
Well, I know he's disappointed you in several ways, I'm sure. But if you've got any mutual acquaintances or family, surely he wouldn't want to cost his mother $15,000. You know what I mean? And he needs to know that that's what's about to happen. Okay, thank you very much. Commonwealth of Kentucky versus Gerald Profit. Gerald Profit. That is a diversion completion, and I'll sign the order. Now let's go back on the in-person docket. Where are we on Bruce Cove? Okay. Yes. Was there already a warrant out on Mr. Ray? It's the FTA then. Okay. A motion's been tendered, Mr. Cole, that says you wish to enter a guilty plea. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Are you the same person named in this indictment? Oh, and we're here for the sentencing. Okay, and now I put away the pre-sentence investigation report. Okay. Have you had an opportunity to review the pre-sentence investigation report done by probation parole? Is it substantially correct? Counselor, is there any reason this gentleman should not be sentenced today? Upon a plea of guilty of assault second, the defendant shall receive a sentence of 5 years probated. For 5 years, probation is to be supervised. He agrees to stay out of Cumberland County, Kentucky, and have no contact with the victims or victims. What is the court cost to fine? Okay, the court costs are $210. You need some time to pay that? Okay, well, I will allow you to pay it $30 a month. First payment start 30 days from today. Okay. Need to meet with the probation and parole officer over there just to give him some information, okay? Thank you. Yeah, sure. Have a great day. Okay, do you have the paperwork done on Brandy Lee Franklin? Okay, that was the last in person that we have, correct? Well, when he comes out, we'll do that. We'll go. What time is the Barron County docket set for? Oh, they transport it. Okay. Well, I will take a break here and let you go back there. Now, do you have any of these people, the people that are in Casey County, do you have that person? Okay, how about LaRue County? Do you have that person? Mr. Cross, we'll go to, is LaRue County on there now? LaRue County Jail on there? They don't appear to be on yet. Taylor County Jail?
Yes, Your Honor.
That's yours, Mr. Bell. Taylor County Jail, it says Brad Sheffett. You what? What about Aaliyah Hurt, Mr.? Wait just a second. Commonwealth, Kentucky versus Aaliyah R. Hurt, 21 CR 00124. Are you Aaliyah Hurt?
Yes, sir.
You need to turn the microphone on, young lady.
Okay, can you hear
Are
me?
you Aaliyah Hurt?
Yes, sir.
I can't hear you.
You still can't hear us?
Click it again.
We seem to have a microphone problem.
Uh-oh.
Well, we're gonna have to be able to hear anyway.
Okay, can you hear us now, sir?
Unless you want to do one of your famous interpretations. I mean, we've heard your Spanish interpretation. Maybe you can hand sign for us also. Read her lips, perhaps. Okay. Leah, will you see if somebody else say something real loud for me?
Can you hear me?
It's not us.
Well, Megan said that she could hear everybody.
Yes, we can hear you.
We can hear you.
Speakers.
Does this have the speaker in it?
Microphone, yeah, it's got the microphone. See the
Yeah.
webcam? Say speaker. Hello, testing.
So that means we're working, right?
Yeah.
This is Casey County. We can hear you.
Okay. Yeah, I think it works on our end, appears to be.
Yeah, we can hear you clear.
Good.
Hear me or go, I couldn't hear her.
Ayla,
Yes.
Oh, yeah, there you go.
Okay.
Okay. Commonwealth, Kentucky versus Alea, is that how you say your name?
Ayla.
Ayla, okay. This is 21 CR 00124. You're here today on a pretrial conference. Mr. Bell, what do you have to say?
You know, I've talked to Mr. Stockton, and we wanted to set up another discussion on this. case.
February the 11th for a negotiation day, and the next court appearance is the 24th of February.
Thank
Now,
you.
we have one other person up there, it would appear, and that would be Anwar Barber.
Yes, sir.
Thank you.
Anwar Barber.
Come on in, sir. He is right here, sir.
Thank you, Tony.
Thank you very much. Are you Anwar Barber,
I am.
born in 1980? Last four digits, social security number 5536.
Yes, sir.
You're on a motion to revoke. What does the Commonwealth have to say? Mr. Stockton, are you on the line or where are you? Mr. Stockton. Is Mr. Stockton trying to get on the air back there? Could somebody, Mr. Bailiff, could you go back there and see if Mr. Stockton's trying to?
On 27.
Good, trying to get connected.
Just that.
Technical problems today. It's St. Patrick's Day.
Didn't think that March 17th, is that? Okay. There's Mr. Stockton.
Hello, Mr. Stockton.
Just had to boot my computer up now.
Okay, this is Anwar Barber, and you have a motion to revoke. Could you state what the motion is?
Yeah, I have Andrea, I think it's at Balt or Bolt is on from probation parole. And it's a motion to revoke and it's for not attending treatment or appearing in front of his probation officer and take testimony. It's,
Does your client want to stipulate?
Your Honor,
Mr. Barber does admit to not going in person to those visits. He would like to explain to the court what happened.
Okay, ma'am, you raise your right hand. Turn your microphone on. You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
Identify yourself and with whom you're employed in what capacity.
Andrea Balt, probation and parole officer.
You may proceed, Mr. Stockton.
Thank you. Ms. Bald, have you been supervising Mr. Barber?
Yes, sir.
And how long have you been attempting to supervise him?
Since June of 2021.
What types of violations has Mr. Barber had since June of 2021?
Since June, he has had positive drug screens. He's received new indictments out of Taylor County, and then his failure to for his SSC evaluations, failure to follow through with this.
Let me ask you about his drug screens. What types of drug screens has he failed, tested positive on? When?
He has failed for marijuana and methamphetamines.
And what date did those occur?
11/18/2021. And then 1/13/2022, as well as September and July of last year.
Okay. And how many of those were positive for methamphetamine?
All of them.
All of them.
Yes.
So did I understand that it would be 4 total?
Yes.
Okay. Now, also you said you scheduled him appointments to see the SSC. Is that correct?
Yes.
And how many of those appointments did he fail to appear at?
4.
4. And can you have those dates in front of you?
I do. He was scheduled to meet with the SSC on 7/26/21. He failed to make that appointment. That appointment was rescheduled to August 2nd of 2021. He failed to make that appointment, which was scheduled for September 20th, 2021. He failed that appointment, was scheduled for 11/22/21. He failed that appointment. The SSC said she could no longer see him right now because he continues to miss.
And I have in your notes that he would not only no show, but there would be no call
Yes.
to the SEC saying he wouldn't appear.
Yes.
So
never
the way
called
I
no shows.
understand your testimony, he was showing up for you and doing his drug test, but then he wouldn't go to these SSC appointments.
Yes. And the SSC appointments were relatively easy because a lot of times they were on the phone. He wouldn't even call. She couldn't get in touch with him.
Now, you said he also got indicted in Taylor Circuit Court. Is that correct?
Yes, sir.
And what was those charges?
He's got 2 cases pending in Taylor Circuit. One is for possession of a firearm by a convicted felon, and that's 21 CR 265. The other one is 21 CR 270-3, and that's possession of meth first, and then drug paraphernalia.
Do you know the dates those offenses allegedly occurred?
I don't know the dates that they allegedly occurred right now, but I have the dates that they were indicted.
Okay, and when were they indicted?
They were indicted on 10/7/2021.
Okay. I have no further questions, Your Honor. I believe you're muted, Your Honor. I can't hear anything. I have no further questions.
Right now.
Officer
Yeah, I can hear
Bolt. Okay. Officer Bolt, can you hear me?
Yes, I can now.
Okay. Officer Bolt, Mr. Barber, what was his first day on supervision?
He began supervision on 12/18/2019.
And then you began supervising him in June of 2021. Is that correct?
Yes, ma'am.
And do you know if Mr. Barber is enrolled in school or working?
I do believe he is enrolled in some sort of college classes, the best I remember. I think he's mentioned that to me the last time he reported to me.
And he is reporting to you, is that correct?
Yes, he just won't report to the SSC.
And do you know of any phone issues that Mr. Barber has had?
Not to my knowledge.
You did say some of the SSC appointments were over the phone, is that correct?
Yes, they were scheduled to be on the phone due to COVID restrictions.
Nothing further, Your Honor.
No redirects, Your Honor.
You have any other witnesses, Mr. Stockton?
No, Your Honor.
I wish to call my client, Your Honor, if I could.
Mr. Barber, do you wish to testify?
Yes, sir.
Okay, you know, you have a constitutional right to remain silent. You want to waive that?
Yes, sir.
You may respond to your attorney's questions.
Mr. Barber, why were you unable to contact the social services clinician?
The very first time she called me, we did have a phone session. It was really spotty and the service was so bad that she said that she would just meet me in the office whenever I came in to report, but she was never there. And then the second time she called, again, we had issues again with the phone because I lived in Acton, Kentucky at the time. And we corresponded through text messages, and I did keep those messages on my phone as well. And that's when I informed her that I was enrolled in college to get my bachelor's degree in business administration with a specialization in human resource. And I let her know that I was making a 4.0 grade point average, which I maintained that all the way up until my arrest. She congratulated me on attending school and making good grades, told me to keep.
Your Honor, this is not responsive to the question.
Ask him a question.
Mr. Barber, were you referring to communicating with the social services clinician?
Mrs. Phillips, I think is her name, the one for my counseling session over the phone.
Okay. And you are enrolled in school?
Correct.
Okay.
The question is why did he not respond as required to the person that was supposed to be providing services?
Your Honor, I believe he stated that he had.
Yes.
I didn't understand that. I couldn't follow what he was saying. He was
Understand.
talking about he and she and what he was doing and it. And
I apologize.
Mr. Barber, did you contact the social services clinician at probation and parole?
Yes, the very first time she called me, we did talk on the phone. The service was bad, being that I live in Acton, Kentucky, and she told me since the service was bad, she would just meet me in person when I came to report, but I never saw her there. And the second time she called me again, we had service issues over the phone. Of course,
hang on, Mr. Barber, when you say she called you, who are you referring to?
Miss Collins, no, Miss Phillips.
Is that the social services clinician?
That's just correct. That's, as far as I know, that is her name.
Okay. And did you communicate with her via text message?
I did. I still have those text messages too.
If the judge were to not revoke you today, would you make any appointments that probation and parole get assigned to you?
From here on, anytime that she wants to have a phone call or a meeting, make sure I was in town somewhere where I had phone service, and I will wait. And I will make contact and do those meetings. And as far as that, I will not that's either.
All right, thank you, Mr. Barber. Nothing further, Your Honor.
Mr. Stockton,
I have no questions.
hey, what do you have to say, Mr. Stockton?
Your Honor, this is the second time we've been through this. Back in January of last year, Mr. Barber absconded from probation. He was picked up. I filed a motion to revoke. The court sanctioned him and gave him time served and allowed him and told him to report his probation officer and follow directions. This time, with all due respect to Mr. Barber, if he put in as much effort contacting the Social Services Commission as he did acquiring his methamphetamine, where he tested positive 4 times, he wouldn't be in this situation. So it's apparent that he's not going to follow the directives of probation and parole, and he's not going to comply with his probation. This is the second time that we've had these issues. You know, in this day and age of technology, you can get in touch with somebody if you want to. And if you can acquire meth, you can use a telephone and call somebody. So I'm asking that he be revoked.
Your Honor, for Mr. Barber's testimony, he was communicating somewhat with the social service clinician. He did not substantially comply. and I'm not-
Let me tell you something. This is the second time Mr. Barber has not complied with instructions. If I was looking, going back to jail, and I had to say, can you hear me now? Like everybody has to say it once in a while, it'd be the #1 priority in my life to make that contact and to make sure I was compliance. So I think that with all due respect to Mr. Barber, this is one of the things that my dog ate my homework. Where's your homework? He did not do his homework, and I'm revoking him. And whatever the parole board wants to do and give him another chance, that's fine with me. Okay, thank you very much. So that finishes our jail at our Taylor County Jail. Thank you, Taylor County, for your cooperation.
Could you tell me the date the judgment was entered? Your Honor, could you give me the date the judgment was entered on Mr. Barber?
Where's the file? She can get it for you.
We'll bring her the file, Your Honor. Ms. Vanderpool will bring her the file.
Okay, Casey County, are you on there? Be on there.
Yes, Your Honor.
Okay, we have Savannah Branham. Ms. Costello, you represent Savannah Branham?
I do, Your Honor. I had her on 21 CR 139. My understanding is now the Monroe County case has been transferred to Cumberland. I have
22 CR 00001.
Yes.
Possession case transferred from Monroe County.
Yes, I have not received that one yet, but I do currently represent her on the 21 CR 139. Mr. Stockton did let me know about the other case that was coming. So we were going to ask to set for a negotiation day.
Well, what's going on this case here?
Your Honor, she is a state inmate and we are trying to wrap up these additional charges. She was already revoked out of Cumberland County.
On 21 CR 00139, it's not resolved though, is it?
Not today, Your Honor.
I'm just.
No, that one needs to be on the
Today,
settlement.
tomorrow, next week, it's not resolved, and we got the Monroe County case to resolve also.
Yes.
Now, what do I have to do to help you get on the Monroe County case? Do I point you to that or to somebody else?
Your Honor, that's fine. I think it's been transferred now. So if I'm appointed, I can get the discovery and move forward.
20 CR 001, which was transferred over here under the rules of criminal procedure for judicial economy. February the 11th for negotiation, February 24th for a plea. Are we concluded with our business with Ms. Branham today?
Yes, Your Honor.
Thank you, Casey County, for your cooperation. We appreciate it.
Thank you.
Let's bring these two, let's bring the inmates out that were transported from Barron County. And then we only have the Adair County Jail after that, I understand. Commonwealth versus Robert Stevenson.
That's a sentence.
Do you have your client stuff then?
Yes, sir.
Okay, we'll do that. Thanks. We'll do these two.
Thank you, sir.
This is sentencing on Robert Stevenson.
Yes.
Could, Mr. Garner, could you connect the LaRue County Jail to see if they got the link we sent? loosely are connected to the same organization you are.
I need.
Commonwealth, Kentucky versus Robert Stevenson. Are you Robert Stevenson? Yes, sir. It's 21 CR 0000113. You're here today for sentencing. Have you, and also 21 CR 00126. Have you had an opportunity to look at the pre-sentence investigation report? Is it substantially correct? Yes, sir. Counselor, is there any reason why this gentleman shouldn't be sentenced today?
No, Your Honor, the only thing we did want to advise the court of, part of his agreement is to pay restitution. He's still being held on a state case. He's hoping to be released in May, so he will start restitution payments as soon as he is released.
On a plea of guilty to receiving stolen property and persistent felony offender, defendant shall receive 7.5 years. Plea of guilty to receiving stolen property over $10,000, he received a sentence of 7.5 years. The 2 7.5 years terms shall run concurrently, however, and should be probated for 5 years. Probation should be supervised. Defendant agrees to pay restitution at $2,000 of $2,000 rate, $100 a month to Rhonda Ray. First payment being due in 30 days after sentencing. And the 15th of each month, every day. Court costs amount of what? $450. You can pay that at an additional $50 a month. I also want to make the period of probation for 5 years or until the restitution is paid.
That means your payments as you're ordered, you'll be done. But if you know.
Is that okay with the
you
Commonwealth?
can't get off probation.
Yes.
so that's good.
Yeah. I'll sign this restitution order.
Yes. Should you do that? Because if not, then we won't get it. And you'll probably have to meet with Officer.
Michael Vibbert.
Your Honor, do you want me out front or on the computer? Mr. Collins is going to testify, but he's got to testify by Zoom because he's under quarantine.
Okay, well, you can stay back there if you'd like.
Okay, thank you.
Commonwealth, Kentucky versus Michael Shane Vibbert. And I guess, Mr. Vibbert, you were born in 1977.
Yes, sir.
Last 4 digits, social security number 1680. Who's your attorney?
Johnny Bell was represented in this case.
Judge, I was, and I'll continue. I didn't know Mr. Vibbert had been put back in jail. And if you could give me a little time to see exactly what's going on.
Well, I'll let you listen to this, and then you can ask me if you want some time to talk to him. Okay. He might want to stipulate after he hears it. Who knows? You got a witness you want to put on, Mr. Collins?
Yeah, Mr. Collins.
Mr. Collins, you raise your right hand.
Yes,
You
sir.
swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
Is that the Adair County Jail? Do you have your camera on? You take your camera off till we call your case, and y'all be next, okay?
Okay.
Go ahead, Mr. Stockton.
Mr. Collins, have you been attempting to supervise Mr. Gilbert?
I have.
And I guess going back to approximately, I guess back in the summer of last year, is that when his violation started?
Yes.
Could you tell the courts what happened, what's happened since then?
On 6/25 of 2021, Mr. Vibert was arrested and charged in Monroe County for fleeing or evading. Second, no registration plates, improper registration plate, driving on DUI, suspended, failure to own or maintain required insurance, failure to register, transfer a motor vehicle. On that day, he was drug tested and he signed an admission form for the use of methamphetamine on or about 6/24 of 2021. We set Mr. Vibert up with the SSC. And at that time, I left any further discretion of the court. To my knowledge, he had followed through with all his IOP and his meetings of life skills after that positive drug test. So he was compliant with that. After that, it looks like on 11/10 of 2021, Mr. Vibert was indicted in Monroe County, 21 CR 127 for trafficking and controlled substance, first degree, first offense, meth, possession of methamphetamine, drug paraphernalia, and PFO second. We released Mr. Vibert on bond. He was supposed to be on an ankle monitor because his wife, Penny, had COVID. She was in the hospital. So we released him to be put on an ankle monitor because he wanted to be with her. And on 11/12/2021, Mr. Vibert reported as directed. He did tell me that his wife had passed away. And he stated that he needed, at that time, he wished to attend a rehab program to gain control over his life. So on 11/18, we enrolled Mr. Vibert into a 6-month program at the Men's Addiction Recovery Center program in Bowling Green, as recommended by DOC. And on 12/1/21, I received an email from Officer Jennifer Stone, who supervises the offenders while at the Mark Rehab Facility. She asked if Mr. Vibert was present in Monroe District Court on 11/29/21. Officer Stone stated that Mr. Vibert told a new employee at the Mark Center that he had court. He signed out stating he had to be in Monroe County to attend that court. I called the Monroe County Clerk's office, and they did verify that he did not have court on 11/29/21. So as of 12/1/21, Officer Stone stated that Mr. Vibert never returned to the Mark Center. She stated that he had not been terminated as this date, but the facility did not know when he was planning on returning. I tried to get in touch with him, called numbers, which all yielded negative results. I checked local jails and hospitals, which also he was not there. And at that time, a warrant was issued for absconding supervision.
And did Mr. Vibert ever turn himself in, or did he have to be arrested?
To my knowledge, he was arrested by Lucas Geralds on, I believe it was 1/13.
Okay, of this year.
Yes.
Okay, I have nothing further on.
You have any witnesses you'd like to call, Mr. Bill?
I'd like to ask a few questions, I guess, Judge. If I could have maybe 5 minutes to talk to my client, sure.
We emailed this to Johnny.
Judge, if I may, please, before I ask a few questions.
Sure.
Officer, can you hear me?
Yes, I can.
I know what you stated on the first violation that you're saying that my client had, that he was given the task of going to IOP and following some other instructions. According to your testimony, he followed through with all that, done as he was told to do.
To my knowledge, yes, he did.
Okay. And then you say, when was the next incident? Was that when he came in concerning the passing of his wife, or what was the next situation?
No, he was, Mr. Vibert was arrested on 10/11/21 on a new felony case in Monroe County. And at that time, we put a probation hold on him when he was arrested on that new felony case.
Now, was that during the time that you let Mr. Vibert out of jail for some situation or circumstance?
Yeah, yes, when he was arrested on that case, I was informed that his wife was in the hospital with COVID and she was on a ventilator and she wasn't doing good. And I had spoke with the judge in the Commonwealth, and we made a decision to release him on the ankle monitor so he could be with his wife, as he thought that she wouldn't make it.
And she did, in fact, passed away.
She did, yes.
And was it after that that Mr. Vibert came in and asked to go to rehab himself?
Yes. He come in, said he wanted to get a grip on his life and requested us to get him help.
So this wasn't something that was court order or anything you ordered him to do. It's something he voluntarily asked to do.
He did volunteer. We had him assessed, and per Department of Corrections, the only way you can get into the Mark Center in Bowling Green is by way of referral of an SSC or with DOC.
Okay. And after that is when he signed himself out and y'all didn't have any more contact with him? Is that the situation?
That you are correct.
I'll pass the witness, Judge.
Mr. Stockton?
Just a couple questions on redirect. Mr. Collins, we've referred to this arrest for trafficking in Monroe County several times. You've gotten your memo that he was in his vehicle and he had several baggies, meth, and approximately 16 grams of meth and $608 in cash. Is that correct?
Looking at the
from the
memo,
officer's memo.
Yes, looking at the memo, that is correct. Meth pipe, meth bones found inside the vehicle, $608 in cash. The meth weighed out to 16 grams.
Okay, I have nothing further.
He's not been convicted on that case, is that correct?
To my knowledge, it is, he has not been convicted on that. I believe he has arraignment scheduled for 12/9.
Do you know if the labs are even back on that case?
I have no knowledge of anything but just the charges.
So all you know about is the allegations?
Yes, just the allegations, yes.
That's all I have, Judge.
Nothing further.
Okay. You have anybody else, Mr.?
No
Yeah,
other
Your Honor.
witnesses, Your Honor.
Okay, I'm sorry, Mr. Bell.
I'm going to allow him to testify, Judge, if you could swear him.
You have the right to remain silent and wait for that. You understand? Swear testimony about to give us truth, whole truth, nothing but truth.
Yes, sir.
State your full name.
Michael Shane Vibert.
Mr. Vilbert, I'm just going to ask you about a portion of this. Could you explain to the court why it is that you asked to go to treatment?
Because I've got a bad meth addiction.
And can you explain to the court why after they put you in rehab that you left rehab?
Well, I had like Mr. Collins has stated, just buried my wife a day before I was supposed to went to rehab. I didn't know it at the time. I went in to see him the day after I buried her, and he said I had a 12 o'clock appointment that day, but he got it fixed to where I could go the next day, be there at 12 o'clock. And I've got a 12-year-old son that's out there right now. And I didn't have time to explain to him what was going on at that time. And when I got to the Mark Center, I went for treatment. I went to get help, and I guess you could say that the March Center ain't all it's cut out to used to be.
Just state to the court exactly what the problem was in the situation.
Well, when I got there, I didn't know I was gonna be 10 days before I could talk to my family. And when I did call and talk to my son to try to let him know what I was doing and what was going on, the first thing he asked me was, "Daddy, do you not love me no more?"
Was there any drugs or anything in the facility?
Yes, if you wanted them, there could be.
Was that a problem for you?
Yes, sir, it was.
If you had the opportunity to go back, would you complete that? Do you think your life's in order enough since the passing of your wife that you'd be able to do that?
Yes, sir, I do. And yes, sir, I would.
And the passing of your wife, did that inhibit some of your concentration and thoughts on what you were doing and the actions you took?
Yes, yes. I'd had no time to grieve.
That's all I had, Judge.
Mr. Stockton.
Mr. Filbert, many years ago, I think you and your wife was charged with manufacturing methamphetamine. Is that correct?
No, sir, I've never been charged with manufacturing.
I thought you and your wife went through drug court in Monroe County.
No, I did, sir, for a possession charge.
You did, but she didn't go. Is that correct?
Yeah. Yeah.
I thought you was
I done
both in there.
No, no,
But-
sir, just me.
Yeah, and you graduated, didn't you?
Yes, I completed it without a sanction.
What year was that you graduated?
17, maybe?
Yeah. So wouldn't it
And
be
then-
fair to say, Mr. Vilbert, when after you graduated drug court, you had all the tools you needed to deal with your addiction?
That calls for speculation, Judge. I don't think my client would even have the knowledge to answer that because he don't know what all the tools are as of now. Nor do I.
We just say he had some tools.
All right.
Okay. Well,
He's asking.
and then when did your wife get sick with COVID?
And she lasted a month.
Okay.
Should have been in October.
Yeah, in October.
So it was
It was
about,
only-
she got sick about the same time you got charged with having this meth on you, didn't you?
Yes.
That's what I thought. I have no other questions.
Nothing further, Your Honor. I have nothing further, Judge. I'd like to make an argument. Please go ahead, please. Judge,
Once you go to your client's face to the left or right, you get over behind here so we pick you up good.
Judging Mr. Vilbert's situation, I understand there's been some problems, but it would look like from a pattern that when he had the first issue with probation and parole, he was given the order or the opportunity to go through some IOP and do some things to at least aid in the conviction or in his conviction or his addiction, I should say. And it seems like, Judge, that he went through that without any problems or any kind of issues whatsoever, which would sort of tend to me to show that the passing of his wife had a huge impact upon him. And I know it would the children, Your Honor. And I can't speak to his situation or to the court about what impact. I can say when my father died, when I was in my early 20s, my family fell apart, all of us. And I can understand and believe that in this situation, I would be easily convinced that his family has fell apart, and it does take time to go through that bereavement process. And I believe that would have had a big impact on him. And just asking the court from a benefit of the doubt type of situation, in fairness, I would ask that my client be given another chance to go to rehab. It's something he come and asked for. He wasn't ordered to do. And I think that his past shows that he can complete it if he hasn't got the other things going on in his life that caused him to not have the concentration and conviction that he should have.
Mr. Stockton.
Your Honor, I've been dealing with Mr. Vilbert since 2009 when I amended a trafficking charge down when he served about, 2,000 days in jail. He got caught over here in Cumberland County, got a felony, and then he got different charges, at least 2 different charges while he's on probation here, including trafficking. The court was gracious enough to leave him out on a home home incarceration so he could stay with his wife. I'm sorry that his wife passed. He was given an opportunity to go to rehab and get his life straightened out. And he's indicted now for having 16 grams of meth on him in a vehicle. You know, I'm asking for the court to revoke him, but whether the court revokes him or not, I'm done giving Mr. Vilbert breaks. He's either going to go to prison on this new charge in Monroe County or he's going to trial, because I've dealt with him for 12 years and he's been given break after break after break and he's never took advantage of it. And I'm done.
Well, Your Honor, I mean, unfortunately for us in this situation, you have the last call on this, Your Honor.
I don't know whether it's unfortunate for you or not.
Well, I mean, as far as Mr. Stockton's position, it's fortunate for us. You know, so, I mean, I mean, you know, this is a terrible situation, you know, and addiction is a real problem. I mean, and I understand Mr. Stockton's frustration sometimes, you know, I really do. But with addiction, you know, as the court well knows, it's a sickness. It's something that's very hard to get rid of. It's no different than cancer or heart disease or anything else. And I just don't believe that my client has got to a point where the prison is the only alternative to fix him. And, you know, I don't think it will. And I would ask the court at least to give him this opportunity, because you can always round him back up.
Represent him in the other case.
I represent him in one case, but
Yeah, but he has a case pending, right, Mr. Stockton?
I don't represent
That's
him.
correct, Your Honor, in Monroe County, and it's hard to prosecute somebody when they've absconded. Mr. Bell asked if that case has been disposed of. Well, it's hard to prosecute somebody till they get arrested when they're on the run. So it will be prosecuted.
I don't think he's even been indicted yet, so.
He has.
Yes, yes.
Yes, he
Or
has.
been. I'm wrong on that one.
Well, it would appear to me that his best interest to go ahead and take care of that charge over in Monroe County, wrap them all up and serve some time and get the parole board to take care of it. When you think so, Mr. Stockton,
Well, that's going to be my position, because he's used his last break as long as I'm Commonwealth attorney.
you do better on parole than you will on probation.
I'm not handling the new case, Judge. I don't know anything about it. The only thing I can do is stand in for him today.
He's not, I can tell by his head shaking that he's not inclined to want to, that he might have a defense to the thing over in Monroe County. I don't know. But I'd want to get it all wrapped up if it was mine, I think. So I don't see other option I have rather than to revoke him on that thing. And then if he wants to go ahead and take care of that Monroe County thing, we'll take some look at combining it over in this one in some way. That's the way I might be able to help you. I've got no doubt that you have an addiction problem, but the problem is, as in many cases of addiction, you've got these fleeing or evading, burglary, all these other things that are going on here, and possession of meth, and all those sort of things. So I'm gonna revoke him on this, and you know, other thing that goes there. Okay, thank you very much.
Thank you, Judge.
Now, that you can leave with the Barron County prisoners now.
He would get credit for time he's already served, would he, Judge?
Well, we'll see we'll see how the corrections does it. And if he doesn't like the way they do it, he's got every right in the world to administratively address that. And if that doesn't do it, he can peel it back down to me. I'll make sure he's treated right. I don't have any desire to mistreat the man. You were clairvoyant. Yeah, me too. Let's go to Adair County. Yeah, let's call Ms. Franklin's case back. Commonwealth versus I've lost her.
Brandy Franklin.
I've lost it over here. Here it is, right here. Commonwealth versus Brandy Lorraine Franklin, 21 CR 00119. Ms. Franklin, I understand that you wish to enter a plea. Is that correct?
Yes, Your Honor.
Motion's been tendered to that effect. Previously you admitted to having some drugs in your system. Are you under the influence of them now, or do you believe you understand what's going on?
I understand what's going on.
Okay. Are you the same person named in indictment number 21 CR 00119?
Yes, Your Honor.
Have you had time to discuss this matter with your attorney? You feel like you're fully informed?
Yes, Your Honor.
You have certain rights under the Kentucky and United States Constitution in order to accept the plea. I need to know that you understand those rights. You understand that you have a right not to testify against yourself. No one can make you say anything. A right to speedy trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your behalf, the right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty and charged against you by entering guilty plea today. You give up those rights. And I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. Prior to accepting the recommendation, I will await the pre-sentence investigation, court and probation and parole. In the event that I do not agree with that recommendation, do not agree with the Commonwealth's recommendation, I can reject the plea agreement and sentence you to more time. However, if you don't agree with that, I'll let you withdraw your plea. What is the Commonwealth's recommendation in this case? We all step to your left there a little bit.
Your Honor, Ms. Franklin's charges of tampering with physical evidence, marijuana cultivation, and possession of drug paraphernalia are to be dismissed. Upon the defendant's plea of guilty to possession of a controlled substance, first degree, she shall receive a sentence of 3 years, pretrial diverted for 5 years, supervised. The defendant shall enter and complete a long-term treatment program in a facility scheduled through probation and parole. She, of course, shall receive credit for time served. She shall pay cost and court cost in the discretion of the court. And as a part of her diversion requirements, shall obtain gainful employment or do a minimum of 30 hours a week community service. Further, she agrees that any and all contraband and drug paraphernalia be disposed in accordance with the laws of the Commonwealth.
Now, have you been previously diverted in the last 5 years?
No, Your Honor.
Have you been convicted of a felony in the last 10 years?
No, Your Honor.
Are you presently on probation?
No, Your Honor.
Pretrial diversion means as you successfully complete the terms of pretrial diversion, the case will be dismissed and you can have it expunged and you will not have a felony conviction on that. Okay. However, if you violate the terms of pretrial diversion, you'll be brought back before the court. And if you are violative of that, and I find you are, I'll revoke it, order pre-sentence investigation report, you'll be a convicted felon. That can be used against you in any felonies in the future. Okay. Now, since this is a diversion, what I'll do is I'll sign it if you got it there. Mr. Bailiff, could you cover that? Now, who you live with?
I have my own apartment.
Do what?
I have my own apartment.
So have you, I told you you have to turn yourself in today at 4 o'clock. That'll give you time to make arrangements for your children, right?
Judge, may I ask you, just bring up one issue very quickly. We have found 3 different places that we think would be suitable for my client, Ms. Franklin, to go. I think we could get her in there very quickly. The only issue that I would ask the court to consider is the COVID situation. And if I'm not for sure, we've been having some problems if you're in jail on the quarantine time before a rehabilitative center will take you in to the premises.
How quickly can you get her in?
I think we would get her in prior to Monday or even no later than maybe Tuesday. I've called a lady down in Glasgow that does it a whole lot.
What kind of situation are you in prior and anything? What is your relationship with your mother right now? Is it good?
We're
Do
on,
what?
look, it could be better, but we're on.
Well,
good terms.
I know
Yeah.
that it's ebbed and flowed because she's been over there working herself to death all these years and you've been having these other problems and it's caused a problem between you, hasn't it?
Yes, Your Honor.
And you can understand that.
Yeah.
If you knew your daughter was headed down that road, you'd tell her she didn't need to go, wouldn't you?
Yes, Your Honor.
Okay, so if you can make arrangements to stay at your mother's home and be restricted to there and not go anywhere else and submit yourself to any officer that wants to come in to search where you're staying in there and do a drug test on you. I'll allow you to stay there to your mother's. Okay? So you need to, you're gonna be in custody if you can't make that arrangement, have your mother call my office and agree to that before 4 o'clock today. If you don't do it by 4 o'clock today, you need to report yourself to the Adair County Jail. And I understand the COVID situation, but if I was betting my bet, I'm thinking you probably hanging around some places you can get the COVID too. I mean, I'm not saying that you don't judiciously wear your vaccine. Have you been vaccinated? It hadn't scared her up to this point, Mr. Bell, whether she's going to get COVID or not. But you think that she'll turn the corner on this new health kick she's on, right?
Well, Judge, it's more about getting her into the treatment, where you get your thinking right.
Okay, all right, well, you call and make arrangements of that and have her in there and then she will be the one that transports you. Now, who else do you have might transport besides your mom? Be careful, it's not a known drug dealer in the county or something, okay?
Her or my grandmother would.
Okay. Okay, well, you make sure you do that, and I expect you to. I tell you what, rather than call my office, call a Commonwealth attorney's office. They give you a number, and that way, Mr. Stockton, y'all will know for sure that she's complied with a court order. She'll call your office and make sure she's made arrangements to stay at her mother's and not leave her mother's for any reason until she's transported to the rehab. Okay?
That's your mama's got a call.
Okay, thank you a lot.
Thank you, Judge.
You need to meet with the probation and parole officer over here to get information.
Judge, would you permit me to ask you about one case very quickly?
I don't believe I can keep you from it.
I have been representing Louis Arms on one case, DPA's has 2. When we was here negotiating, the DPA got a resolve for all 3. I was just asking to be removed from the case so that they can go ahead with the plea. I won't be in the way any longer.
I didn't think you were in the way, but I understand your
You can be
position.
related to it. Okay,
Thank you.
how many more cases you got?
That's it.
Okay,
Thank you, Judge.
Yeah.
Thank you.
wait before you go here. I mean,
Yes.
it's just something here. Mr. Louis Arms, Adair County.
She has 2 cases and an arraignment.
Okay, this is Mr. Louis F. Arms, 21 CR 0058, 21 CR 00159, and 21 CR 00137. You have an arraignment, Mr. Arms, in 21 CR 00159. Mr. Arms, were you born in 1964?
Yes, sir.
Last 4 digits, social security number 8381.
Sir.
Okay. The grand jury of Cumberland County has returned an indictment charging you with a convicted felon in possession of a firearm. You acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty on that charge, ma'am.
Yes, Your Honor.
Okay. Now we're dealing with all 3 charges. Do y'all have a resolution?
Your Honor, we have a drug court referral today, and then we're hoping on February the 11th at our settlement conference, we can have the paperwork done for all 3 cases.
Okay, we'll have a negotiation day, Mr. Arms, on February the 11th. Your attorney will be in contact with you to look at a global settlement. And then on February the 24th, we will come back to the next plea. I'm going to assign a reciprocal discovery order. Mr. Arms, now I just want to make a personal observation. I don't want to get involved in any kind of discussion with you or anything. But I've known you most of your life. You've known me and everything. I tell you, every time I put you in jail for about 60 days and stuff, you come on and look like you're the picture of health. Then I let you out and you get kind of on the wrong path. I don't guess you want to volunteer to serve a life sentence or anything, but it ought to tell you that being away from some of that stuff improves you. I mean, your demeanor's good now and you're healthy looking. Wouldn't it be good if you could be like that all the time, man? You know?
Yes, it would.
Yeah, it's a hard thing though. I understand. Okay, well, that on January the 11th and then on February the 11th and February 24th, okay?
We have the drug court order.
Yeah, I'll sign the drug court order and take a look at drug court.
Thank you, Your Honor.
Okay, who do you, Adair County, you got Mr. Bricker? Paul,
We do.
Yeah. Okay, Paul Bricker.
Judge.
Yes.
If alphabetically, we just go down the list. We've got them all ready to go. All right.
That'd be good. Okay. It's like Happy, was it Happy Chandler said who was it said we're gonna do this alphabetically starting with A? Who said that? That was Ed Diddle.
Yes, sir.
We'll do this-
It did
we're gonna-
line up alphabetically according to height.
Yeah. Okay. Commonwealth, Kentucky versus Paul Bricker. Are you Paul Bricker?
Yes, sir.
21 CR 00148. You're here for a pretrial conference. Sir, were you born in 1985?
Yes, sir.
Last 4 digits, social security number 1839. What do you have here, Mr. Stockton? What do you have?
Well, I spoke to Mr. Kraus about this case one time, and he was supposed to get me a counter offer and an offer, but I've not heard anything from him as far as bond or anything like that. I told him what I needed. So I guess if he's ready, set it for trial, fine, or if he wants another pretrial, fine.
Your Honor, the last time Mr. Stockton and I spoke, we talked about trying to get Mr. Bricker out on bond. I have spoken with Mr. Bricker, and Mr. Stockton wanted to know who he'd be working with and where he'd
No,
be.
we're not here to talk about his bond yet. You can bring that up in a few minutes.
Okay, I'm sorry. Well,
I'm talking about a resolution of the case.
well, we missed our negotiation session because I had COVID rampant through my office. and-
Okay, well, we'll set up a new negotiation day on the 11th and the next court appearance is on the 24th. Now you can bring up the bond.
Thank you,
issue.
Your Honor.
Yes.
Your Honor, I spoke with Mr. Bricker. Mr. Stockton wanted some confirmation of this. So what I would propose is we get written confirmation from Jeff Mowers that Mr. Bricker will be working for him and living in his home when he is released. People are desperate for workers. Mr. Bricker's a talented fella. And I'd like to get him out on bond where he and I could have a
Well, let me talk to me a little bit if you're going to do that. I don't know anything, obviously, Mr. Bricker, about your case. You know, I'm not supposed to that much, but I want y'all to tell me he's charged here with possession of a handgun and a firearm and wanton endangerment and assault, 4th-degree violence with minor injury. So I don't care who agrees to take him out. I'm going to have to be convinced that he's not a danger to someone. So we're
Well,
going to
the
have to have it.
officer in this case, Your Honor, thought it was a dangerous case, and I told Mr. Cross that once he developed a plan, that, and he could get that to me, I could talk to the officer and talk to the victim and see if that'd be appropriate. It's not something we need to do in court. I need to know ahead of
I agree.
time so I can confirm these things, and then the court can
That's
make a decision.
exactly right. That,
Yeah.
We're all on the same page.
that validates how I'm feeling about it. I
Okay.
didn't know anything about it.
Well, what we'll do, we'll set that forth to the court and Mr. Stockton in a motion, and then Mr. Stockton can review it and see where we are.
Yeah, you can do that, or if you know, if you give a written proposal on what kind of bond conditions, let the Commonwealth check with the officer and investigate it. You might do it by the agreed order. I don't care whether you do it by motion or not, but that's what we'll do. But 11th and the 24th. Okay, thank you. Today?
No, it's already been produced for 10 years, the DVO.
Yeah, there's a DVO in it in the case
Yes.
also.
Yes.
Okay.
Your Honor, the court had inquired a while ago about LaRue County. The only other, no, I've got two other cases. I've got Mr. Castillo.
Charles Brown.
So we'll wait.
Charles Brown.
Came out April 20th.
What?
You continued him and his wife. Until April 20th.
April the 28th. He and his wife were continued to April 28th. Mr. Brown, I understand, had COVID or something. Is that right? I guess I'm still.
Yeah, he had COVID according to Mr. Vaughn.
Okay, well, Mr. Brown is, case is April 28th. He and his wife also. Next one is Nathan Costello. Commonwealth versus Nathan Costello, 21 CR 0009. Okay, you are Nathan Costello.
Yes, sir.
Yeah, and this last four digits, social security number 3232. There's a motion for KCPC evaluation filed.
Your Honor, the motion is self-explanatory. When I spoke with Mr. Castillo, and the court's familiar with Mr. Castillo, and the court's also familiar with his good, solid background. Mr. Castillo's statement to me was, I don't understand why I'm doing these things. I'd like to know what's wrong.
I understand. As a matter of fact, I'll inform you and the prosecutor's office that I received a very disturbing written communication from Mr. Costello, which was a very borderline situation, and I'll provide you a copy of it.
Thank you.
And I'll provide the Commonwealth a copy of it. I don't know whether he might have served it. Get a copy, yeah, we'll get a copy for you.
Wasn't aware of any communication.
Well, I understand. So we'll just continue this case generally right now. Can you put a pin on him?
Ask.
That way, and we'll just wait till that evaluation happens. Now, as you're aware, there's a considerable delay.
Yes.
But
he's
I'm
not going
involved in
anywhere.
talking to members of the legislature now to see if we can do something about that. I hope we can, about these. You know, I know we have these private vendors at KCP that public defender gets me to do ex parte motions, but it would appear to me that with this backlog that we have, that it wouldn't be inappropriate in certain cases for the Commonwealth to be able to make the same sort of motion where they could get independent evaluations done by a contractor. We couldn't do it on all of them, but you know, it's unfair to everybody involved, the Commonwealth and the defendants, not be able to get this. Okay. Next one is.
Your Honor, may I interject? The only other matter I have left is with Mr. Nedry in LaRue County, and all we
can't get him.
Well, all we need is a date. And I'll be
a date for what?
A date for a hearing.
Well, what kind of hearing do you want on it?
Suppression hearing regarding all issues relating to the blood test, all issues.
Well, we'll just, what's your position on that, Mr. Stockton?
He's not available. Let's just get a date next month. He's a state prisoner, so on another case, so I don't mind getting a date
Let's
next
just
month.
schedule him. Do you have to have expert witnesses? What kind of suppression you want?
I have to have the investigating officers that work the reg. Also, Mr. Cross is inquiring about chain of custody. I'm gonna have to line the lab people up. So it's gonna be an extensive hearing, and I'll probably have several witnesses.
It is, Your Honor.
March 31st, after we finish the civil docket, we should have some time on March 31st. Let me check the calendar and see if that's going to be a problem. No, let's do it. Megan, are you on there? What time do you suggest on March 21st? Take about an hour, I think.
Probably starting at 3 would be the safest because we always do confidential cases at 2.
Okay, let's do it. Yeah, let's schedule it. Can we schedule it at 2:30? And then we'll, thinking that if we can't get to it, we might have to push it over, because if we schedule it at 3, anybody that's going to testify on Zoom or something is in Eastern time zone, it's 4 o'clock.
Good point.
So
That date works for me.
we'll schedule it on the 31st at 2:30.
Your Honor, I do believe that concludes your business with the court today.
Have a great day.
Thank you.
Taylor Chambers, are you Taylor Chambers?
Yes.
Is your birth, are you born in 2001?
Yes.
Last 4 digits, social security number 6405.
Yes.
Okay, you're here on a pretrial conference. What, y'all reached a resolution in this case?
We have not yet, Your Honor. Mr.
February the 11th for negotiation date and February 24th. Now, how long has this young lady been in jail?
Your Honor, she was arrested shortly before her.
Is pretrial on there? Vanessa, are you on?
I'm here.
What kind of bond does this young lady have?
She was arrested on 110. She has a no bond. She had got a new charge in district court and I think it was dismissed. PI.
We're breaking up.
Can you hear me now?
I can hear you now.
Okay. She was arrested on 110. She has a no bond. She had a new charge in district court of a PI, but it has since then been dismissed.
She was on a home curfew, I think, living with her mother, Your Honor. And we got complaints on her, and Junior Smith tested her, and while she was on curfew, she tested positive for methamphetamine. That's the reason her bond was violated.
Okay, we'll see you on negotiation on February the 11th, the next court date on February 24th.
Thank you, Your Honor.
Okay, Brittany Cowan. Commonwealth versus Brittany Cowan, 21 CR 00099. Are you Brittany Cowan?
Yes, sir.
Born in 1996.
Yes, sir.
4 digits of your social security number, 7385.
Yes, sir.
You're here today for the purpose of arraignment, ma'am. You have the right to remain silent.
Sentencing, Your Honor.
I
I'm
mean,
sorry.
for sentencing, you have the right, have you read the pre-sentence investigation report done by probation and parole?
Yes, sir.
Upon a plea of guilty to possession of controlled substance, first degree, you shall receive a sentence of 3 years, pre-trial diverted, however, for 5 years. Diversion is to be supervised. What's the
She was already pre-trial diverted it's been voided and she's been sentenced.
Okay, well, that's. Okay,
She stipulated and was voided last month, Your Honor.
my paperwork didn't match what we're doing here, so. So she should be sentenced to 3 years.
That's correct, Your Honor.
What was the court cost?
Hers was $320.
$320, pay $50 a month, starting when she gets out, every 30 days from the day she gets out. Okay. Okay. Thank you. Keisha Crawford. Keisha Crawford. Commonwealth versus Keisha Crawford, 21 CR 00147. You're here for today for arraignment. Is that correct, Madam Clerk? Okay, could you give me the Bible? You have a right to remain silent. Are you represented by the Office of Public Advocacy?
Yeah.
This is Brittany Cowan. The grand jury of Cumberland County's returned an indictment charging you with theft by unlawful taking or disposition. You understand that charge? You're represented by the Office of Public Advocacy. Public Defender's Office represents you.
Asking you what?
I don't think I have a lawyer yet.
You want direct submission? Well, for the purpose of arraignment, I will appoint Office of Public Advocacy. Raise your right hand, Ms. Crawford. Swear the testimony you're about to give is the truth, the whole truth, nothing but the truth.
Yes.
Do you have a job?
But I'm not in here.
Have you had a job in the last 6 months?
Yes, when I'm not in jail, I do.
Do what?
Speak up.
When I'm not in jail, yes, sir.
Okay, well, I'm appointing Public Advocacy to represent you. This is your attorney, Ms. Costello. Way better, Ms. Costello. Hit the microphone.
Ms. Crawford, I'll be your attorney. I'm Samantha.
Okay. So, got a $15,000 clerk approved surety, which appears to be reasonable. Negotiation will be on February the 11th, and then plea day on February 24th. They'll either transport you down here, or your attorney will go up there and meet you up there to negotiate on the 11th. Your next court date's on the 24th.
Your Honor, we had to extradite her from Florida. We put her in NCIC, and I would ask for some type of secured bond.
Okay, we will make her bond. We'll make her bond, no bond until we look into it a little bit more. Because she had to be extradited, okay? Thank
Your Honor,
you.
I think she would be entitled to some type of bond.
Okay, $1 million. I got a right to hold someone that's a threat risk. I don't know whether they're entitled to bond anyway, if they abscond and won't come back to the state, but. I'll sign a reciprocal discovery order there. James Cursius, Alfred James Cursius, 21 CR 00136. Are you Mr. Cursius?
Yes, sir.
You're here for a pretrial conference. Your attorney is Ms. Costello. Were you born in 1985?
Yes, sir.
The last 4 digits of social security number 5305.
Yes, sir.
Okay.
Your Honor, Mr. Crecilius is being held on a new felony. We did the prelim yesterday. I've spoken to Mr. Stockton. He was okay with resetting this so we could discuss both
February
cases.
the 11th for negotiation. And the 24th for a plea. And I guess, is the grand jury going to be presented with the case today, or they get it in time under Mr. Stockton, you know?
They should be returned. I think, is Mr. Judd out there? I thought they were finished.
Well, if they hadn't, you can proceed by information for negotiation purposes.
Yeah, it should be returned today.
Okay, February the 11th, February the 24th. Dale Cross.
No.
Commonwealth of Kentucky versus Dale Cross, 21 CR 00158. You are Dale Cross, is that correct?
Yes, sir.
Born in 1958.
Yes, sir.
Last four digits, social security number 7749. You're here today for the purpose of arraignment. You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with wanton endangerment in the first degree, another count of wanton endangerment in the first degree, terroristic threatening, and public intoxication. You understand those charges?
Yes, sir.
Madam Bailiff, you want to present those to the defense counsel. You acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motion.
Yes, Your Honor.
I'm signing a reciprocal discovery order, Mr. Cross, where they're having to give you the evidence they have so your attorney can help prepare a defense. We schedule this on February the 11th for negotiation, and the next court date, February the 24th.
Your Honor, I did have a question about Mr. Cross. The bond is listed on the indictment as 10,000 cash, and the docket says 10,000 cash and 25,000 cash. We would just ask the court to go with the $10,000 cash bond if we could at this time.
These are the same birthday. So.
I don't have, what, it's 25,000.
Would the court consider reducing it to 10,000 cash at
You
this
want to
time?
file a motion? I mean, you got, are these officers involved here?
I believe one is, Your Honor.
Yeah, well, we need to have a hearing on it. You know, so you just get a hearing. I don't, Mr. Cross, they've got a right to have a hearing to reduce your bond, and I don't want to have it today without you getting a chance to prepare for it, because you just get one by right, okay? So your attorney will be taking a look at that. Commonwealth versus Jeffonda Cundiff. Jeffonda Cundiff. Commonwealth versus Jeffonda Cundiff, 19 CR 00104. Are you Jeffonda Cundiff?
Yes, sir.
Born in 1970.
Yes, sir.
Last four digits, social security number 7768.
Yes.
Do y'all have a plea agreement? in
We do,
this?
Your Honor. It's a felony plea.
Okay. A motion has been tendered, ma'am, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 19 CR 00104?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
You understand the charges against you. You had plenty of time to discuss this matter with your attorney. You satisfied with her advice?
Yes, sir.
You do not have to enter a guilty plea. You have certain rights under the United States and Kentucky Constitution. Before I can accept a guilty plea, I know that you need to know your rights. You don't have to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, right to be represented by counsel at your jury trial, a right to confront and cross-examine all witnesses called to testify against you, your right to produce evidence, the right to call witnesses in your half and have process issue to compel their attendance. You have a right to appeal this matter to higher court if you lose, and a right to require Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. By entering a plea of guilty, you can get all those rights. Now, You said this was a felony plea?
Yes, Your Honor.
Okay, I can consider the Commonwealth's recommendation, but the court can't apply any range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I will wait to see the pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, I will reject the plea agreement, and you have a right to withdraw your plea and ask for a jury trial. You understand that?
Yes, sir.
What is the Commonwealth's recommendation, Mr. Stockton?
Your Honor, Ms. Cundiff would plead guilty possession of controlled substance, first degree, receive a sentence of 3 years, probated for 5 years. Probation is to be supervised. It will run concurrently with the Dyer Circuit Court and Bullitt Circuit Court. She paid court costs at the discretion of the court. Obtain and maintain gainful employment. All evidence in this case be destroyed.
Is that what you agreed to?
Yes, sir.
Is she presently a state prisoner?
Your
One of those
Honor,
other pleas?
she was sentenced on Tuesday in Adair County and last month in Bullitt County.
So we can waive the pre-sentence investigation report on her?
It'd be something, Your Honor.
Yeah.
Yes, and I've spoken to Ms. Cundiff, and if the court is willing, she would like to do that.
Okay, are you, you're entering a guilty plea because you are guilty?
Yes, sir.
You understand that this could be used to enhance any sentences in the future of additional felonies you have. You understand that?
Yes, sir.
Okay, does the Commonwealth have any objection to me going ahead and entering a judgment in this case?
No, Your Honor.
Wait, so we'll go ahead and enter a judgment. I'll accept the pre-sentence the recommendation of the Commonwealth and waive pre-sentence investigation. Okay, thank you very much.
Thank you.
Your Honor, at what rate should she pay the court costs?
I'm gonna waive it. She's
Thank
got
you,
those
Your
other-
Honor.
Other two things going on. She got all those other charges. She paid court costs in 2 other counties.
Thank you very much, Your Honor.
Buddy Dyer. Buddy Dyer. Commonwealth versus Buddy Dyer, 21 CR 00135. Are you Buddy Dyer?
Yes, sir.
Okay.
We've had discussions, Your Honor, but we need one more negotiation day. I've got some people I need to consult with on this case.
Okay, we'll schedule a negotiation date for February the 11th in 21 CR 00135. The next court date is 24.
Thank you, Your Honor.
Okay. Raymond Garrett.
Okay. I knew we discussed it, so I didn't know. We did the plea paper.
Commonwealth versus Raymond Garrett, 18 CR 0052. Are you Raymond Garrett?
Yes.
Born in 1983.
Yes.
Last 4 digits of your social security number.
8717.
Okay.
Your Honor, Mr. Garrett was in COVID quarantine until yesterday. I was going to ask for one more settlement day.
I thought we were gonna take care of this today.
No way to take care of it today, because when we talked to the glass, you didn't want to take care of it.
Well, wait just a second. What was the Commonwealth's offer in this case?
I think it's a probated plea with restitution, Your Honor. But we've not done the paperwork because we never did get the.
How much restitution?
I think it's $2,270.
Now, are you, what was it 3 years probated for 5 or what was?
I think it was 5 for 5.
5
That was
for-
our offer.
So the offer is 5 years probated for 5 years and restitution of over $2,000.
Yes.
Okay.
You know, we could do this plea the next motion day somewhere if you want.
Well, is this gentleman eligible for a pretrial diversion?
I don't think so from looking at his NCIC report.
Well, let me ask him, have you been pretrial diverted in the last 5 years on anything?
No, sir.
Have you had a felony plea in the last 10 years?
No, sir.
Are you on probation?
No, sir.
Well, I'd say he's eligible for a pretrial diversion And if he reached an agreement on the 2,000 and whatever dollars it is, we could send the paperwork up there today if you can do a pretrial diversion thing, and we might let him do it.
Well, that's fine.
That's fine with me. Is that what you want to do, Mr. Garrett?
Yes, sir.
Okay, well, we'll get the paperwork up there to you, and it'll be a little.
Your
while.
Honor, I think he has a prior felony conviction out of Tennessee. I'd ask that you ask pretrial. I don't know that we're getting the correct answer.
Do you have a felony conviction in Tennessee, sir?
Yes, sir. I'm on parole in Tennessee.
Okay, you're not eligible then for pretrial diversion.
I didn't think he was. From looking at his
Okay,
license.
so we'll schedule a negotiation day on the 11th, and then, well, I don't see a reason we couldn't send the paperwork to him on this thing today and get.
We could do the plea and release him at sentencing if the court, if he'd agree to that, because I don't want to release him before he's sentenced. Unless he make bond.
I can't make bond.
Okay, well, let's go ahead and send him the plea documents today. And we can get him back online and enter a plea. And that way we can have the pre-sentence investigation report done and get ready to sentence on the 24th. That'd save you a month, sir. You know what I mean? It'd save you a full month. Okay, thank you very much.
So when will I come back to court?
24th for sentencing. If you waited to the 24th, if you waited for the 24th to plea, it would be March 31st before I could sentence you. So by doing it this way, we save you over a month. Okay? You'll be out over a month earlier. Okay, thank you very much. Bradley Gunter. Bradley Gunter.
Michael, how would you pay in the $2,000?
Commonwealth versus Bradley Gunter, 21 CR 00152. Are you Bradley Gunter?
Yes, sir.
Born in 1987.
Yes.
Last four digits of social security number 1687. You're here today on a pretrial conference. Y'all have a plea?
We do, Your Honor.
What kind of plea is it?
It's a felony plea, Your Honor.
A motion has been tendered, Mr. Gunter, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under? Kill my knee there. Jeez. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in 21 CR 00152?
Yes, sir.
Have you discussed this matter with your attorney and are you satisfied with her advice?
Yes.
Have you had plenty of time to review the evidence and you believe you're fully informed about your case?
Yes, sir.
You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea of guilty, I need to know that you fully understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witness in your favor, the right to appeal this matter to higher court if you lose, the right to require Commonwealth prove on a reasonable doubt that you're guilty of charges against you. You understand, by entering a guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation. I do not have to accept it prior to accepting. I will await the pre-sentence investigation report and my probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to give a harsher penalty, you have the right to withdraw your plea and proceed to trial. What is the Commonwealth's recommendation?
Your Honor, Mr. Gunter would plead guilty to trafficking in a controlled substance, first degree, over 2 grams, receive a sentence of 6 years. He would serve 6 months, balance probated for 5 years. Probation is to be supervised. He would forfeit $2,168 to the Cumberland County Sheriff's Department, Burkesville Police Department. He'd pay court costs at discretion of the court. Once he's released, he'd maintain and obtain gainful employment. All evidence in this case would be destroyed.
Is that what you agreed to, sir?
Yes, sir.
Okay. Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
Knowing your constitutional rights have explained to you, including the possible enhancement of future felonies because of this plea, you agree to go ahead and enter this plea of guilty?
Yes, sir.
Is that your signature on the motion?
Yes.
I mean, and you signed it? Okay, I'll accept the agreement, order a pre-sentence investigation report done by probation and parole, and schedule a sentencing on February the 24th. How much time does he have in now?
Your Honor, we were trying to calculate it yesterday. It's around 90 days, but not exact. And I didn't have the exact number yesterday.
How much does he got to serve?
A total of 6 months.
Okay, so he'll be all right to do the 24th, okay? Okay. Come down there. I'll just take a brief pause here and go down and meet with the grand jury.
the blue board in. I think that's the one that it is.
Is anybody else running or? So you guys are the same party, so it's. Okay. Since it's just a primary, somebody can't come then later and file the other ticket claim and then you have to do a general, right? Or could they?
They would have to file in their own party. Somebody could have filed as a.
John Smith.
So once it's passed, yeah, once it's
That's
passed,
right.
yeah.
Yes, that's right. Yes, yes, yes.
They can't then change their mind and
No.
there's no, you know.
He do
File
that?
deadlines passed.
I think it's a social effect.
I think it's all that county attorney.
Special
person.
Well, yes, killed the one witness because it was.
It doesn't make sense that county attorneys and Commonwealth attorneys are partisan and judges are non-partisan. I mean, don't get me wrong, it makes perfect sense that judges are non-partisan. I just think that that's, yeah.
Some states have been for it, probation, the public defender is an elected position.
Mhm.
To me, that makes no sense. You know, you're elected prosecutor. So we've been going through that council for the county. And that makes no sense going back.
In Arkansas,
That I don't know.
almost like a hybrid system. So they have some public defenders who are elected and then some,
Copus boy, he was bad.
but there was a main public defender in like Little Rock. Because that's such a big town that had like a full staff. And I don't know, I can't remember if that main person could be elected as well. What do you think the huge staffing change would change?
Yeah.
But, so it was, but like some county public defender, but there was some election. And they had gotten rid of some and some. hadn't, and it was odd. So now, what I like about not having elected officials, as far as the defender system is that I think it gives us more autonomy to get jobs.
That's certainly true.
You know, because if you made the wrong thing, you know, I would be concerned that people wouldn't or wouldn't defend their clients if it was a really bad case. You know, just defending that kid, and then the community get mad, so, and you know.
That's the elected versus appointed judges.
Right.
Stop the whole way to totally trying her without politics.
That'll be the hurt as it.
I don't know.
I don't know.
Robin.
It's nothing hard.
So are you taking over the case or y'all just been working on it?
You know, I'll probably do. Trial.
She's already served a year.
Heard it say,
Yeah,
Right now. It's been several months since we had.
Okay. Well, I appreciate it. Thank you very much. It's, yeah. Thank you, Mr. Mills. I'm trying to get that one resolved, though. Okay.
As far as politics in general, I have no strong, I mean, I have some strong feeling, but I believe that whoever wants to get rid of my student loans has my vote.
Trials.
I've got one that's gonna be caught February 7th. Roma, it's in Scottsville. Roma has got one of the co-defendants and I've got. And anxious to watch it from the perspective of being able to see Owens and Steve Owens.
A couple of years ago.
You said that? You think that?
God. They charge you.
You think I'll try and stall and see that? I'd love to get okay.
That's the problem. It was.
There's no.
Do
y'all grab that and take it?
I'm not aware of that. I just saw where there's a piece of jewelry on the outside door and one.
That would. You know what I mean?
I don't know what they are.
Okay. Yeah, she's not even have her ear pierced. So it's not.
And I looked at the 41s and I couldn't tell.
I think there was just in the boy's bedroom, like a small ears. There was.
Is there several?
You've got the stuff that came from her dad's garage. I don't know what else there would be to connect her to it. She was with me and she was there. I feel jittery.
An alibi.
That's why you have to. I became a public defender, so.
Well, they were there. They were people on the radar early. And Dewberry and the sheriff's them. And they heard stories. They were on with the baby. Of course, Jay Dewberry found out that the baby wasn't there. Them and alive there. Dewberry,
So you run into kids.
That's the way.
Real close. That first night, in there.
And I guess it's when the two first came to the house.
And later, somewhere else.
One child was going.
Yeah, that's so together.
But I can.
Been down to see. Oh, yeah. Would be parked a few steps. Down the road.
Now, was it parked on the street?
It's not true. Rule says.
You have the location of where the farm had been parked.
That's key. That's right.
I need to find out which time that lasts between all that.
You go right out of high school.
Somebody left their children. I don't know. That came into mind. I had to make that.
Somebody left it.
I want to pick the one outside.
That's in the door jam, in the doorway.
See that, it's one item outside and one inside. 41.
It's not always separate, sometimes.
They should have broke y'all in.
I get bored, I sometimes take one of these cases to fiddle with them. I've always found, I forget, disregard what everybody says initially. The pictures and see what the story is. I always thought that the picture would tell you. No. This is swing job of that. It's a good shot. The other one. Security, you know what I mean?
Bang back.
Probably instantaneous.
But I don't know.
But I mean, there are a lot of questions to me as to how quick all that stuff went. Hearing. Next is the truth. And that's what it is. Yeah.
I don't know where it's going to go. Water got me really good in Casey County when I was brand new. We were doing a case and the officer, I can't remember how exact, it was telling me that there was a witness who was not there. Dr. Cundiff, and he's like, well, I think he was telling me the truth, and I would just can't do that. And I was trying to get rid of the judge, and I've been waiting to be found. Uniform, find out the truth. So from now on, I have never once objected and immediately.
Well, actually, it did, but on the next second trial, that he is where he's probably son of a bitch. That is not the trigger there. He's your son of a bitch. When it is not to prove the truth of the matter, so we're not trying to prove that he is his own bitch. That's what it is. From the precepts.
Okay, let's see if we can get back on the jail docket here. Oh. Are we on Brandon Hall? Is that where we are?
Yes, sir, Judge.
Let's see if we get going again. Commonwealth versus Brandon Hall, 21 CR 00116. Are you Brandon Hall?
Yes, sir.
Born in 1982.
Yes, sir.
Last four digits of social security number 3773. Is that correct?
Yes, sir.
Motion to revoke. What do you have, Mr. Judd?
Your Honor,
I'm sorry.
if I may interrupt, I'm sorry.
It is, yes.
He has 3 cases in an arraignment. We have an agreement on all 3. Or all 4, I should say.
21 CR 0016 is a motion to revoke. 21 CR 0026 is a motion to revoke. 21 CR 0054 is a motion to revoke. 21 CR 00157 is an arraignment. We'll do the arraignment. Okay, sir, you have a right to remain silent. I'm going to arraign you on this charge here. The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance in the first degree, possession of drug paraphernalia, Counselor, you acknowledge the identity of Mr. Hall, received indictment, wait formal reading, and enter plea if not guilty.
Only a plea of not guilty to possession of drug paraphernalia, Your Honor, and we have an agreement on the other 2.
So you're going to enter a plea on all of
Yes.
them, not guilty for the arraignment.
Yes.
Okay. Subject to your right to change that.
Yes, Your Honor.
Okay, now, we have Mr. Hall in front of the court on all of the things, and you're telling me that there is a plea agreement on a felony charge, is that correct?
Yes, Your Honor.
Okay, a motion's been tendered, Mr. Hall. It says you wish to enter a guilty plea on the last indictment, which would be 21 CR 00157, and will combine with some of your other cases. Is that correct?
Yes, sir.
Is this plea voluntarily given?
Yes.
Are you under the influence of drugs or alcohol?
No, sir.
Have you discussed this matter with your attorney, and are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence in your case and you feel like you're fully informed?
Yes, sir.
You understand that you do not have to enter a guilty plea in this case. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights, okay?
Yes, sir.
Not to testify against yourself. No one make you say anything. Your right to speed trial by jury, your right to be represented by counsel at your jury trial, your right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to fill this matter to a higher court if you lose, the right to require the Commonwealth to prove on a reasonable doubt that you're guilty of the charges against you. You understand that by entering a guilty plea today, you give up those rights. Now, I mean, consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Now, is this gentleman a state prisoner now? He's not.
He will be stipulating and be revoked, but as of right now, no.
So we'll have to do a PSI on this new charge.
Yes, sir.
Okay, prior to accepting any recommendation, I will await the pre-sentence investigation report from probation and parole. If I do not accept the recommendation, I will and decide to impose a harsher sentence. You have the right to withdraw your plea on this one charge, okay? Now, Mr. Judd, what is the recommendation, the global recommendation in this case?
Okay. The Commonwealth agrees to dismiss possession of drug paraphernalia upon a plea of guilty of possession of controlled substance first degree. The defendant shall receive a sentence of 1 year to serve. The defendant having stipulated probable cause and thus the 1 year sentence shall run consecutively with Cumberland indictments 21 CR 00054, 21 CR 00116, and 21 CR 0026. The defendant shall pay a fine and cost of discretion of the court. The Commonwealth imposes probation. The defendant agrees to have any and all drug paraphernalia and concubine destroyed consistent with the laws of Commonwealth and holding agency.
Okay, now that first year was under 21 CR 00157, is correct?
That's right.
It's
Yes.
a new indictment.
Yes.
And
Yes,
and of course, for the purpose of sentencing, Mr. Hall, it's important that we differentiate because Department of Corrections will want all those and they'll cause you problems if you don't get it. It's the reason I'm bringing those various things up. Is this what you agreed to, sir?
Yes, sir.
Okay, you understand by entering this guilty plea, this adds another felony that can be used against you on persistent felony offender law. You understand that?
Yes, sir.
Or you're entering a guilty plea because you are guilty and for no other reason?
Yes, sir.
Okay, well, I'll go ahead and accept the plea, await the pre-sentence investigation report to be done by probation parole and schedule sentencing on February the 24th, okay? Thank you. Thank you. Dustin Lee Hayes. Okay, Commonwealth versus Dustin Lee Hayes. Are you Dustin Lee Hayes?
Yes, sir.
Okay, this is 21 CR 00138. This is a motion to revoke pretrial diversion. Is your year of birth 1986, sir?
Yes, sir.
Okay, and the last four digits, Social Security 7836.
Yes, sir.
Okay, what do you have to say, Mr. Judge?
We'd like to have a hearing to complete the motion to revoke.
Your Honor, I'm sorry, I spoke to Mr. Stockton. We were going to do a drug court referral on Mr. Hayes.
It's okay then, if that's the case.
Well, what was, I want to hear what the testimony was first. You want to come around here?
Yeah, Mr. Garner.
Mr. Garner, you raise your right hand. You swear a testimony about to give us the truth, whole truth, nothing but the truth.
Yes, sir.
State your full name and your position with whom you're employed, and then answer Mr. Judge's questions.
Jeremy Allen Garner, probation and parole.
Mr. Garner, as part of your official duties, have you had an opportunity to supervise Dustin Hayes?
I have, but I don't think, it wasn't for very long.
Okay. Do you have information in regard to his history of how he behaved or what he did and didn't do to comply with his probation?
Yes, on December 16th, he was granted a pretrial diversion, and then on December 18th, 2 days later, he was arrested on new felony charges. When he was taken to the Dare County Regional Jail, he was given a urinalysis where he admitted to using benzos and marijuana and methamphetamine.
Do you have anything else to present?
Not unless you want the details of his new felony arrest.
What was the detail of the new felony?
Yes.
He got charged with careless driving, drug paraphernalia by possess, and possession of controlled substance, first degree, first offense, methamphetamine.
So based upon what you've testified to, then he's had a problem with methamphetamine twice. Is that correct? Plus other drugs.
Well, he was arrested on methamphetamine charges, and then he tested positive for methamphetamine at the jail.
Okay.
Along with benzos and marijuana.
Anything else you want to tell us, Mr. Garner?
That's all I got.
What county was that arrest in?
Cumberland.
Cumberland County. Now, where is that in the process? You want to come back over? and get mine?
We have had the preliminary hearing, Your Honor. I think we had that on the 22nd, December 22nd.
She bonded over?
Yes.
I think he was indicted.
Yeah, and what Mr. Stockton and I had talked about is a drug court referral because of the continued use, and then wrapping that charge up with that.
So you want him back here on February 24th?
Yes, Your Honor.
Okay. So I will revoke the pretrial diversion on that day probably. Can you put a pin on him or?
Not for pretrial diversion, Your Honor.
Okay, I'm revoking the pretrial diversion. And then we'll do a pre-sentence investigation report. We'll serve him sometime during the intervening time. And then you can include that in your investigation, this new charge. We'll have him served in jail, so he will have been served. And don't
You
you
want
think?
to sentence, Your Honor, on the probation since he's going to serve?
Yeah.
That's Your Honor.
Okay.
Your Honor, is it okay if we go ahead and do the drug court referral? Is that acceptable?
It doesn't bother me to sign the drug court referral to see if they accept him and get it on the line. Of course, he'll still have to stay there until he gets
Yes.
sentenced, and then I'll have to orient him. Okay? Thank you very much. Tessa Humphrey. Tessa Humphrey. Mr. Hayes, you're going to be there on the 24th to wrap all your stuff up. You got indicted today on that thing that was in district court. That way, we're on the 24th. We're going ahead and do the drug court referral now and do the pre-sentence investigation report. And that way, we can get you headed toward drug court a couple of months earlier. Okay?
Thank you, Your Honor.
Okay. Tessa Humphrey. Commonwealth versus Tessa Humphrey, 21 CR 00153. Are you Tessa Humphrey?
Yes, sir.
Born in 1984, last four digits, social security number 5068. Is that correct?
Sir.
You're here on a motion to revoke bond. What do we have, Mr. Judd?
Oh, we have a motion to revoke and to forfeit the bond.
Okay, what do you got?
She missed court on 12/16/21. And then Mr. Philip Staley was notified by mail that he's the surety on her bond that she's missed, and we want to forfeit the bond, but I don't know if I don't see him in court.
How much was the bond?
According to what I have, $15,000 surety bond.
Your Honor, I can say that Ms. Humphrey turned herself in on the 18th after she had missed court.
She called the next day and she got her court date, so she said.
Okay, the clerk informs me that she called the next day and said she had her court dates. So I'm respectfully going to not revoke Mr. Staley's bond. I'll keep her in jail for missing the day at FTA, but there's no reason. Now, how far along are we on her case?
She missed her arraignment, Your Honor, so she has not been arraigned yet.
So we can arraign her now?
Yes.
Okay, you have her file? Okay, ma'am, I'm going to do your arraignment. The grand jury of Cumberland County has returned an indictment charging you with theft by unlawful taking or disposition, auto $500 or more, but under 10,000. You understand those charges?
Yes, sir.
Okay, I'm going to ask your attorney, do you acknowledge receipt of the indictment, waive formal reading, arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, now, Janessa, what before she got her days messed up, what was the deal on her? What, did you take a look at her?
She had done a $15,000 surety. She had been calling in and leaving messages.
Yeah, well, what I'm gonna do is I'm gonna let Mr. Staley off of the bond, but I'll let another approved person on the bond if she's there. I don't see where there was any terrible intent. If she just got her days mixed up and she called in and then turned herself in immediately, I don't see that she's in. You're not gonna run off on us, are you, Miss Humphrey?
No, will Mr. Philip Staley still be able to?
You'll have to get somebody else to sign the bond unless he wants to come back in and sign a new bond. If he wants to come back in and sign a new bond, seeing that he almost lost that first one, I think he needs to get another bite at the apple, that he has to sign another one and make another decision. You see what I'm saying?
Yeah.
Okay. We'll see you on the 11th for negotiation and the 24th or your next court date. Both of those will be conditions of your bond.
And that's at 1 o'clock on the 11th. It's a little different than we normally do. So it's 1 o'clock here in the courthouse.
Well, you're gonna see her before then, won't you?
Yes, I just want that.
You don't need to be getting your dates mixed up anymore. You've had your one get out of jail free, okay? Okay, Christian Jones.
Yeah.
Christian Jones.
Your Honor, this is a case where there's a special prosecutor, Mr. Brian Wright, and we need to withdraw on this or pass it over to him.
There's several cases here, 2 cases. Has Mr. Wright been notified to be here today?
He's been notified that he needs to file the motion, Your Honor, is what I've been told. But no, he's not here today. Could we just continue this till we make sure that he's notified?
Let me see what this fellow's charges are here. Did y'all have a conflict on this, Mr. Judd? Or?
Yes, we do.
The original one, yeah. The new one, no.
Okay. So he's going to be assigned 21 CR 0068 and 21 CR 0. Does the prosecutorial advisory committee, do they do that? He has to do an entry of appearance, doesn't he? As a special prosecutor, how's that work?
Mr. Stockton was doing 21 CR 68, the one that's on for sentencing. It was the older one that Mr. Wright did.
Yeah. Your Honor, the Commonwealth has a problem with 19 CR 84, but not on 21 68.
Well, I have 2168 as a pretrial conference. You said,
He was on for sentencing.
okay.
So he had missed his sentencing date. So yesterday I reviewed his PSI with him in case the court sentenced him today. I just wanted to be prepared.
Well, I want to keep that open, and I think both these cases ought to be transferred to Mr. Wright to try to look up something globally to him. Does that make sense, Mr. Judd?
Yeah, it does to me.
So, okay. Okay, so what's the process for me to notify Mr. Wright on the case? Would PAC do it, or do I do it, or what happens? Mr. Judd, you know?
I don't know, Your Honor. We don't mind notifying.
Mr. Hunley, do you know what the process is?
No doubt, Your Honor. I don't know what stage this one's in.
Well, there's one of them that he just got arraigned on, and one of them he's about to be sentenced on, and I put off the sentencing until the other one.
The 19 CR, he's already been sentenced, and Jesse got a motion to revoke him on that one. That's the one that Mr. Wright.
So the other one is a revocation. So there wouldn't be anything wrong with me sentencing him today on the other charge, and then let Mr. Wright handle the revocation. Okay. So hand me the one he's up for sentencing on.
You have the sentence.
I don't have a PSI on that judge because he's not scheduled for sentencing.
I have a copy from you, Your Honor.
They have it, and they say they reviewed it, the PSI. Do you need a copy of it back there, Megan?
No, I'm just telling you, I don't have one printed off and marked for you.
Okay. Well, they already have had it and reviewed it, evidently.
He's on for sentencing.
Do what?
He's on for sentencing a couple months ago.
Yeah.
So that's all I'm done.
Megan, you see any reason why I can't sentence him today? So the one I'm sentencing him on is 19 CR 0067.
21 CR. Not paying it.
Wrong page. 21 CR 0068 one's been sentenced on, correct? Okay. Have you reviewed the pre-sentence investigation report, Mr. Jones?
Yes, sir.
Does it seem to be correct to you?
Yes, sir.
Okay. Is there any reason that this gentleman should not be sentenced?
No, Your
Okay,
Honor.
I don't have a copy of the order in front of me. Could you recite what the court, what the sentence should be?
Yes, Your Honor. Upon a plea of guilty to theft by unlawful taking over 500, The defendant shall receive a sentence of 5 years, probated for 5 years, probation to be supervised, agree to pay restitution in the amount of $2,100 jointly and severally with co-defendant Jimmy Webb at a rate of $100 per month. First payment being due within 30 days from sentencing and on the 15th of each month thereafter.
What's the court cost? Court cost is $210. I'll let you pay that at $30 a month, starting first payment $30 a day included. So it makes a total of $130, $100 to restitution, $30 to court costs, and other court costs is paid. Now let's go to the other case.
Your Honor, please, in that case, what I have, the Commonwealth had agreed to dismiss a criminal trespass, also receiving stolen property and PFO, second degree.
That'd be
What I have on my offer.
Okay, that's correct. Okay, now on 19 CR 0084, that's the revocation.
Yeah.
And that's when Mr. Wright has to do, right?
Yes, Your Honor.
Can I get a bond on that, Your Honor, please? Or some type, I mean, I followed all bond conditions last time, pretty close to the letter. I didn't, you know.
We've got to get Mr. Wright involved in it, the special prosecutor. So I'm directing your attorney to get in contact with Mr. Wright and see how Mr. Wright feels about a bond, and I'll take a look at that, okay?
Okay.
Thank you very much. Jimmy Otterson.
I'm in here too.
Jimmy Otterson. Commonwealth versus Jimmy Otterson, 19 CR 0067. Mr. Otterson is represented by Mr. Eric Artel Bates, who did not appear last time, and we have clerk's office has told me that they've contacted him this time, but they didn't get back. Mr. Otterson, has Mr. Bates been in contact with you?
Yes, sir. I spoke with him once.
When?
About a week ago, sir.
Did he know about this hearing today?
To my understanding, he did, yes, sir.
Okay. Okay, well, I'll issue a show cause order for Mr. Bates to be held in contempt and fined $1,000 unless he show cause why he wasn't here appropriately today. And reschedule this case for February the 24th. And where are we in the case? What were we going to do today? We're going to set a trial.
Trial date, yeah.
Okay, well, what we'll do is I'll also say that Mr. Bates shall contact you directly, the Commonwealth Attorney's Office directly about a trial date. This Mr. Otterson is in jail and deserves the attention of his attorney and the attention of this court in setting him a trial date to make sure that he doesn't languish there without opportunity for a speedy trial. Thank you, Mr. Otterson. Jonathan Keith Owens. Okay. Commonwealth Kentucky versus Jonathan Keith Owens, 17 CR 0014, 20 CR 009, and 21 CR 00155. Okay.
Judge, he has those two matters. One's a revocation, one is a new charge. I spoke with Mr. Stockton about it. Also met with Jonathan. We're waiting for an answer on I guess, a parole eligibility concerning his good time credit. We may have this resolved, and we'd be able to resolve both of those cases together. I spoke with
Does he have one that needs to be arraigned on?
No, he has been arraigned, Judge.
Okay.
If we could have a February date, I think we'll have to resolve both of them.
Okay, you need a negotiation day of February the 11th, or do you need just to go straight to the 24th?
I don't need the negotiation day. I'm happy to be here.
Okay, 24th of February. And so they're going to try to get all your cases resolved on that day. Mr. Owens, evidently they got a parole eligibility question they got to find out from the Department of Corrections, okay? Okay, thank you very much.
Thank you, Judge.
Karen Michelle Spears. Commonwealth Attorney versus Karen Michelle Spears. Are you Karen Michelle Spears?
Yes, sir.
This is 21 CI 00122. We're here on a pretrial conference. Ms. Spears, you were born in 1974.
Yes.
Last four digits, social security number 9237.
Yes.
Okay. What's the Commonwealth have to say about this case?
The Commonwealth agrees to dismiss possession of drug paraphernalia, and upon a plea of guilty to possession of controlled substance first degree, the defendant shall receive a sentence of 3 years, pre-trial diverted to 5 years. Diversion is to be supervised. Upon a plea of guilty to failure to maintain insurance on a motor vehicle, the defendant shall pay a fine of $500. The defendant agrees to be assessed by the Social Services Commission and will follow in recommendation. The defendant shall pay fine and court costs at discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week community service until employment is obtained.
Now, you've heard the offer, ma'am. This motion was tendered. It says you wish to accept this offer. Is that correct?
Yes, sir.
Did you do this freely and voluntarily?
Yes, sir.
Your judgment is not impaired, or you're not under the influence of drugs or alcohol today. Is that correct?
No, sir.
Have you discussed these charges with your attorney, and are you fully aware of the facts of your case?
Yes, sir.
You know you don't have to enter a guilty plea. And I have to understand that you understand your rights under the Kentucky United States Constitution. You have a right not to testify against yourself. No one can make you say that you have a right to the speedy trial by jury to be represented by counsel at your jury trial, to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. By entering this agreement today, you waive those rights. And let me ask you some questions about your eligibility for pretrial diversion. Have you had a pretrial diversion in the last 5 years?
No.
Have you had any felony convictions in the last 10 years?
No.
Are you presently under probation or parole?
No.
Okay.
You understand that if you fully complete the diversion program, the charges will be dismissed pre-trial diversion, and you can get your sentence, your plea expunged. Do you understand that?
Yeah.
And so you are pleading guilty of your own free will. Did you sign that document?
Yes.
Okay, I will enter a pre-trial diversion. You'll need probation and parole will be in contact with you at the jail. What kind of release date was she?
She had no additional time to serve, Your Honor. So she could be released today if the court is.
Okay, well, what I'm going to do, what time do you want her at your office?
You can call me in the morning, we'll schedule it.
Okay. You can call probation and parole in the morning, but I'm gonna let you call them from home because I'm gonna let you out this afternoon. All right, unless you want to stay one more night. What are they having for dinner there tonight?
Lord, I don't know, and I don't want to stay to find out.
Well, that shows.
I'd love to get on out of here.
Okay, well, I'm gonna sign an order getting you out of there then, but you need to call him. What's that phone number?
I'll get it.
Just get it there at the jail? Okay,
They said.
okay, thank you. $710. Now, there was a DUI in it? No insurance, $710. I'll let you pay it at $60 a month. Your first payment starting 30 days from today. Okay? Danny Staten. Commonwealth versus Danny Staten, 20 CR 0070. Commonwealth versus Danny L. Staten, 20 CR 0070. I was gonna say good morning or good afternoon, Danny, but I don't know which one it is, so I'll just say hello.
All right.
Were you born in 1959, Mr. Staten?
Yes.
The last four digits of your social security number is 7826.
Yes.
Okay, you have I understand that you wish to enter a plea today. Is that correct?
Yes.
Okay. Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person that's named in indictment, 20 CR 0070?
Yes.
Can you discuss these matters with your attorney and are you satisfied with his advice?
Yes.
Now, have you looked at all the evidence the Commonwealth has against you and you believe you're fully informed about your case?
That's buying it out. I wanted to get on that discovery on that trafficking charge. I never get one. I wanted to get that, but yeah, like you could never get it.
Judge, he was asking about some CDs. There are no CDs on that. It was only just written discovery and I've given that to him.
Explain it. Can you hear, Mr.? Let's see what your attorney has to say about that.
And I
Speak
think
up loud.
Danny, can you hear me?
Yes.
Yeah, yesterday when we spoke, you had wanted the CDs on the trafficking, thinking there was a video. I asked the Commonwealth Attorney's Office, there is no video on that. It was only the written discovery, which we went over. There's no CDs to that.
Huh. Mm-hmm.
We had been under the impression there might be CDs, Judge, but there's not.
Yeah, something, I mean. So they just going on what somebody said. That's what you're saying.
Right. That's right. And remember, that case runs concurrent with the engaging in organized crime.
All right. Okay.
You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. A right to speed trial by jury, right to be represented by counsel at your jury trial, a right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to part of the Commonwealth prove beyond a reasonable doubt that you're guilty of the charges against you. You understand that by entering a plea agreement today, you give up all those rights. Now, I may consider the Commonwealth's recommendation. Is he a state prisoner now?
He's a parolee, Your Honor.
You know, but so we'll still need a pre-sentence investigation report, right?
Unless he waives here.
Okay. What's the Commonwealth's position on waiving a PSI since he's a parolee?
We'll agree to it, Your Honor.
Okay.
There's multiple cases. I think there's others that are just not on the law.
We probably ought to do pre-sentence investigation report, you know, just to have them straightened out, because we don't want Mr. Staten to get up there and then get confused.
Okay.
You know, they follow those pretty much, Mr. Staten. You've been up there before. It's not your first rodeo, and whatever's in there, it can help you you know, so they understand what you're there. So let's go ahead, not shortcut things, okay? You plead guilty because you are guilty and you gonna waive the rights that I read to you previously?
Yes, could I make it an Apple plea?
No, that's not part of the agreement.
Okay, make an Apple plea. I am guilty.
Yeah, okay. Is that the signature on there?
It is, Your Honor.
Okay. Okay, I'll accept agreement order pre-sentence investigation report done by probation and parole. And I'll see you on February the 24th. Okay?
All right. Thank you.
For sentencing. Thank you very much.
Judge, would you like to call Brian Thompson? That's the only other one I have.
Do what now?
Would you mind to call Brian Thompson? He's the only other one I have, and I've got to go to Barron County.
Oh, Thompson.
There's just two more before him. They've got them lined up there. So I'll be right with you. Okay?
We have Mr. Thompson seated if you want to take him up, sir.
Okay, bring Brian Thompson up then, okay?
Yeah.
Commonwealth versus Brian W. Thompson, 20 CR 00066. Are you Brian Thompson?
Yes, sir.
Okay, were you born in 1980?
Yes, sir.
Last four digits, social security number 4324.
That's right.
Okay. What does the Commonwealth have to say about this?
It's on pretrial conference, Your Honor.
Yeah, what have y'all worked anything out on the case?
No, Judge, we have not. Should be on for an arraignment. Okay.
Already been around.
Okay, he was in jail in Tennessee for a long time.
Schedule is for February 11th, negotiation, and February the 24th.
And Judge, can we address the issue of bond? The
I doubt if the Commonwealth's ready to address it.
I had spoken to Mr. Stockton. He's okay with a $10,000.
Mr. Stockton's not here.
Lanny, did he leave or?
I don't have any information to that effect.
Well, I'll tell you what I'll do is if y'all want to enter an agreement about that.
Okay.
Whatever is okay with Mr. Stockton.
We'll get a hold of him this afternoon.
Well, we can do an agreed order.
Yeah.
Today, tomorrow, whenever, okay?
Okay, thank you.
Okay. Does that finish you up?
It does, Judge.
Okay.
Thank you.
Yeah. Candy Stuber. Commonwealth versus Candy Stuber, 21 CR 00131. Are you Candy Stuber?
Yes.
You're born in 1989.
Yes, sir.
Last four figures, your social security number 4789.
Yes,
You have a pretrial conference. What do you got going here?
Your Honor, we have not reached an agreement in Ms. Stuber's case or Mr. Stuber's case, and I've spoken to Mr. Stockton. We'll need to set a trial date in this. I was hoping for something in March if we could, Your Honor.
Mr. Jonathan Stuber, you can come up there too, 21 CR 00130. Have y'all signed a waiver of dual representation on this?
They have.
Okay, so we just need to, how long will the Commonwealth need out front to get their witnesses here? You have some lab witnesses probably and some other things, won't you?
Could we have just a second? Get the file.
Let me tell you what I'll let you do.
Okay.
If the Stubers don't object to it, we'll let their counsel get up with you and then get me on the phone after you know what kind of expert witnesses, and we'll set them a trial date just absolutely as soon as we can.
Okay.
Does that make sense?
It does.
Okay. I don't want to set a date that Mr. Stockton can't be there. Yeah, I've got some conflicts. Commonwealth versus Shannon Walters, Pretrial will be set for the Stubers on the 24th, but I anticipate that we'll set a trial date before then by agreement.
Yes.
Okay, we can't reach agreement.
Thank you.
Thank you, sir.
Yeah. Shannon Walters. Okay.
Your Honor, the Commonwealth would suggest having a negotiation day on February the 11th.
Okay, let's get him in there.
He has a new arraignment too. That's why, Your Honor.
Are you Shannon Walters?
Yes, Your Honor.
You born in 1978?
Yes, Your Honor.
That's 4-digit social security number 8119.
Yes, Your Honor.
You're here on a pretrial conference on 21 CR 0062 and to be arraigned on 21 CR 00146. You have the right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with theft by unlawful taking or disposition, auto over $10,000. You understand that charge?
Yes, Your Honor.
Okay, what we're going to do is have your attorney to acknowledge your identity, receive the indictment, waive formal reading, arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, we'll set this case for negotiation day on February the 11th. And I'm signing a reciprocal discovery order. Requires the Commonwealth to give you the evidence they have. They don't give it to you appropriately, you can file a motion to expand upon that, okay? The February 11th, next court date, February 24th. Commonwealth versus Jimmy Webb.
Sorry.
Commonwealth versus Jimmy Webb, 21 CR 0067. And that's a pretrial conference. And then that's all I've got on here.
Your Honor, in 67, we had that case resolved. It is set for sentencing. Mr. Webb had, went over a copy of the PSI with him previously. But these new charges have come up, so, but we're ready to proceed to sentencing, Your Honor. Otherwise, he has an agreement for probation. Please to accept that.
I have a motion to revoke on 0023 and a pretrial conference on 0067. Is there another case besides those two?
I think it's 67, like in Christian Jones, that it was listed as pretrial, but it was actually a sentencing.
67, Your Honor, should be for sentencing. I think
That's what I had. Yeah.
December the last office sheet says this matter should be continued to January 22nd. Ensure presence for council Jennifer Cundiff negotiation.
You have a pre-sentence investigation report on this?
yes, Your Honor.
And that's on 67?
Yes, Your Honor.
Okay.
We had an agreement as part.
What's you come with these new charges, but the other one I've got is 19 CR 0023. What are the new charges? What indictment number is that?
Your Honor, I think there was, the allegation was that there was a new felony arrest out of Barron County.
So we don't know about that yet.
You don't know.
No.
And for Mr.
Wait just a second. Please. He's got another indictment today too, here.
Oh.
I guess I can sentence him on 67. That wouldn't prejudice him. What about the revocation on 23? Is that what you're handling?
Yes, Your Honor, there was a question Mr. Stockton had of whether or not the social security numbers were accurate as far as the cases in Barron County. So he wasn't sure whether to proceed or not on that.
So it's still, it'll still float.
Yes.
So I will continue 23 until February the 11th. Next court appearance on the 24th. And when this new indictment gets served, we'll put that on the 11th and the 24th also, so you can negotiate those two together. You understand what I'm saying? Now let's get back to the sentencing. Mr. Webb, if you had an opportunity on 21 CR 00667 to look at the pre-sentence investigation report by probation and parole.
Yes.
Is it substantially correct?
Yes.
Okay. Is there any reason why Mr. Webb should not be sentenced today?
No, Your Honor.
Okay, you need to, I don't have that report in front of me. So will you read what the
As to the agreement, Your Honor.
as to the agreement?
If I can remove my mask, Your Honor. Upon a plea of guilty to theft by unlawful taking over $500, the defendant shall receive a sentence of 2 years, probated for 5 years, supervised. This 2-year sentence shall run consecutively with Cumberland Circuit Indictment number 19 CR 023. The Commonwealth agrees not to revoke in 19 CR 23 regarding the present charges. The defendant shall pay restitution in the amount of $2,100 jointly and severally with co-defendant Christian Jones at the rate of $100 per month. First payment shall be due within 30 days from the entry of this plea and due on the same date each month thereafter until paid in full. Also with, I don't know if you want me, Your Honor, defendant shall receive credit for time served, pay court costs at discretion of the court, shall obtain gainful employment, standard conditions.
210, and I'll go ahead and pay that at $40 a month, 30 days after he gets out. Ms. Costello, that says there that the Commonwealth in that agreement agreed not to revoke on 23.
Based on that case, Your Honor, yes.
Well, I mean, that's the case you got on here, 23, motion to revoke.
Our agreement, Your Honor, was to not revoke Mr. Webb the Commonwealth would not revoke them based on 67.
That's the only two things I got on the docket. Is there any other reason?
There's new Barron County cases, and that's the basis.
I know,
That's
but
the basis for the motion to revoke.
oh, the new Barron County case is?
Yes.
Okay. Okay, well, I'll just leave 23 floating there, and we got the new case, and you'll still be for the 11th, the 24th on that one, and I'll sentence Mr. Webb under 67 pursuant to the agreement. Okay?
Thank you, Your Honor. Your Honor, that's the only matter up ahead. If I could,
Yeah,
have a good day.
Andrew Gene Weiss. Andrew Gene Weiss. Commonwealth versus Andrew Gene Weiss, 21 CR 00120. Are you Andrew Gene Weiss?
Yes, sir.
Okay, were you born in 1998?
Yes, sir.
Last four digits, social security number 9922.
Yes, sir.
We're here on a pretrial conference.
Your Honor, Mr. Weiss also has a new felony that's pending in Cumberland County. He may have been indicted today, I'm not sure. So Mr. Stockton wanted to reset this for a negotiation day to look at both of these.
Negotiation February the 11th, next court date's 24th. What they say, Mr. Weiss, is that an indictment has been returned today. I guess it's a supplemental indictment of some sort or additional charge. So they'll serve that on you, and that way you can negotiate all of them on February the 11th. And on the court date on the 24th, you'll have an opportunity to resolve all of them, okay?
Yes, sir.
Okay, thank you very much. Cassie White. Cassie White. Is this the last case? Yeah, I got it folded there. Commonwealth versus Cassie White, 19 CR 0039. Are you Cassie White? This is a motion to revoke pretrial diversion. She stipulated.
Yes, Your Honor. This case, she was running, I apologize. This sentence was running concurrent with one in Adair County. She's already stipulated there and wishes
Okay,
to
we'll
stipulate here as well.
stipulate in that case. Is she a state prisoner? They sentenced her up there yet?
She's not been sentenced yet. I believe she gets sentenced February 15th.
Well, that's right.
So I guess we can do a 2 for the price of 1 as far as pre-sentence investigation report. And she can be sentenced here on February the 24th. Okay, thank you very much. And then the last case, Jerry Winningham. Arraignment.
And Your Honor, we have received paperwork back on Mr. Garrett. We had skipped over him.
Okay. See you there again. Commonwealth of Kentucky versus Jerry Winningham Jr. Are you Jerry Winningham Jr.?
Yes, sir.
Your year of birth, 1975.
Do it now.
Last 4 digits of social security, 8344.
Yes.
You're here to the purpose of arraignment. You have a right to remain silent. Your attorney is here. I would assume that you had the Office of Public Advocacy, or are you going to have a private attorney?
No, court appointed.
Okay. Okay, the grand jury has charged you with possession of a controlled substance of 1st degree, tampering with physical evidence, failure to maintain insurance on a motor vehicle. Counselor, do you acknowledge the defendant's identity, receipt of the indictment, wait formal reading and arraignment, enter a plea of not guilty on all charges?
Yes, Your Honor.
We'll set a negotiation date of the 11th and a court date of the 24th. What's this gentleman's bond situation? Janessa, are you still with us?
Yes, he has a no bond.
Why is that?
I do not know. He's a Tennessee resident. It looks like he had to be put into NCIC unless there's something that I don't know.
Okay, well, you'll need to contact your attorney, sir. We'll need to contact the Commonwealth attorney, see if we can work out bond conditions on it, okay? Okay, now where's the Garrett case? Garrett case. Got Mr. Garrett still there?
Judge, we'll have to pull him back out of the cell. He's already been put up. It's just a moment, sir.
Is this the pretrial diversion or felony?
Felony plea, Your Honor.
This is the last case on the docket. Child support next, I guess. What?
Mr. Garrett, Judge.
Okay, this is Commonwealth, Kentucky versus Raymond T. Garrett, 18 CR 0052. Mr. Garrett, you were previously here and you indicated that you had some desire to enter a guilty plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
State your full name.
Raymond Thomas Garrett, IV.
Are you the same person named in indictment number 0052?
Yes, sir.
Okay. Have you discussed this matter with your attorney and are you satisfied with her advice?
Yes.
We've reviewed the evidence the Commonwealth has against you and you believe you're fully informed about the case.
Yes, sir.
You know, you do not have to enter a guilty plea today, and I have to know that you understand your rights that you have under the Kentucky and United States Constitution.
Yes, sir.
You have a right not to testify. No one can make you say anything. You have a right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses yourself in a process issue to compel their attendance. You have the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty charged against you. You understand that by entering guilty plea today, you give up all those rights. Now may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. However, if I exceed your agreement as far as the harshness of the penalty, you may withdraw your plea and ask for a jury trial. What is the Commonwealth's recommendation?
Upon a plea of guilty to theft by unlawful taking or disposition over $500, the defendant shall receive a sentence of 5 years probated for 5 years supervised. The defendant shall receive credit for time served. The defendant shall pay restitution in the amount of $2,270 at a monthly rate of $100 payable to the Cumberland Circuit Court Clerk, with first payment being due 30 days from final sentencing. Restitution shall be dispersed in accordance with said restitution order submitted with plea. The defendant shall pay court costs at discretion of the court. The defendant shall remain on active supervision until all restitution and fines and court costs are paid. The defendant shall obtain gainful employment during a minimum of 30 hours per week community service until employment is obtained.
What's the court cost?
$195.
It's $195. You can pay that starting at $40 a month, 30 days after he's released from jail. Is that what you agreed to, sir?
Yes, sir.
Counselor, is there any other issue that you'd like to address?
Your Honor, Mr. Garrett is a Tennessee resident. If he doesn't qualify for a surety bond because he doesn't have somebody in the state of Kentucky, but.
Well, I'm going to go ahead and sentence him, then you can talk about that.
Thank you, Your Honor.
They talked to you about this could be used to enhance the penalty if you had another felony. They explained that to you. You understand that?
Yes, sir.
Okay. I will accept the plea, order a pre-sentence investigation report done by probation and parole. Schedule a sentence on the 24th. Was this a probated sentence?
Yes, Your Honor.
Okay. Do y'all have any problem with him, even if he's an out-of-state person, assigning a surety bond since he's going to be probated anyway? You have any problem with that? Mr. Judge?
No, Your Honor.
I have none, Your Honor.
Okay.
Mr. Carter has, no.
Okay. Well, we'll go ahead. I'll allow you to sign yourself out.
Thank you, Your Honor.
And you'll be back here on the 24th, but you'll need to meet with probation and parole.
Can you release today, Your Honor?
Ken, all right, release in the morning. You'd rather.
So I could go ahead and sign my own bond?
Wait just a second. I'm finding out when you can meet with probation parole officer.
I can meet with them here this evening if I'll be in the office about an hour and a half.
Here? You think you can be back down to Burkesville maybe in an hour and a half from now?
In Columbia, Your Honor.
In Columbia, rather, in an hour and a half from now, if I would go ahead and release you.
Yes, sir.
Okay, well, I'll go ahead and sign a release for you there. Go to probation and parole and give him the information so he can do the report. And you can head down to where orange is a more hospitable color than it is in Adair County. Okay?
Yes, sir.
Okay?
Yes, sir.
Okay. Your sentencing date will be on February the 24th.
Yes, sir. Thank you.
Okay, thank you. Now, is there any other thing to come before the Cumberland Circuit Court? Yes.
Costello has a matter that has arisen on her. I think it does need the attention of the court.
Okay, it's a private matter.
Yes, Your Honor.
Okay.
What's it? Play Samantha up there on private matter. Ken's on big doc looking at this picture. He needs to be.
This is a request to allow the Commonwealth to intervene. Is that correct?
Yes.
Okay. Show it to Mr. Carter there. Doesn't seem to be anything irregular on there. Mr. Carter's a simple motion to allow the Commonwealth to intervene in this case.
That's what it appears to me, Your Honor. All I have is a copy of, or is a proposed order. I don't have a motion, but it appears standard.
Okay. It says now comes the Commonwealth by to Cumberland County Attorney pursuant to 403-211, who's a court to allow Cumberland County Attorney on behalf of the Commonwealth Cabinet for Health and Families to intervene in this action to provide Title IV -D child support services. So I think that's appropriate. So I'll go ahead and sign. Thank you, Mr. Carter. Okay, that ends
Thank
child
you.
support today. Okay, now what do we have? The Dare County child support.
Doesn't appear to be on.
What'd you say, Megan?
She isn't on yet.
She's in one yet.
She's getting on right now. I can't see myself.
Yeah, calling the Adair County child support cases.
Hello, Judge.
Hello. You want to turn your camera? There you are.
Sorry, I had a little trouble. I'm on my way to another court, so I'm in the vehicle, so.
Okay, I'm calling Keith versus Keith, which is CI 00251.
Okay, Your Honor, we're asking for a bench warrant for Mr. Key's case. He owes $11,264.96. The last payment we received from Mr. Keith was in November.
Okay, I'll be glad to issue that warrant. What about Dean versus Sparks?
On that case, on Mr. Sparks, we are asking for an order to show cause.
Okay.
No, I'm sorry. Hold on. I'm sorry. Yes, we're asking for order to show cause for 525 to be paid by March the 31st.
Okay, I'll be glad to enter that.
Okay, Your Honor.
Watson versus McLean.
And then on the Taylor Watson versus McLean case, we are asking for review on that matter to be heard on March the 31st at 1:30 as well, Your Honor.
Okay, submit the orders.
We'll submit the orders. Thank you so much.
Yeah, have a safe trip. Bye. What's next? Okay, we got a short civil docket here. John W. Mahaffey and others versus Nelda White.
I'm on here, Your Honor.
Turn your picture on.
I don't know whether I can or not. I can't tell you I can. Will you ask Mr. Hundley how I do it?
I'll have to, Bobby.
He has one of the victim's advocate to turn his camera on. She's not available at your office today, so I guess you're on your own.
I guess I'll have to be. I can't get it to do it, Your Honor.
Got something been done. Okay.
All I'm asking is a trial date, sir.
Well, I gotta see you now before you get a trial date.
You might not give me one if you saw me.
I don't want anybody to be representing themselves to be Bobby Richardson and then we take up a trial date now. What I want you to do is, do you have a mouse or do you touch your thing or
using the mouse?
Okay, go over to the left bottom corner and there's a little microphone there that's red with a bar down to it. Just push that, that'll unmute you.
You hear me?
Well, I hear you. Now there ought to be a little
Judge,
there's a little camera down
I'm
there.
looking at the.
Now
Let's
push the little
see.
camera right next to the little microphone.
I don't believe, I'm not sure how he signed in, but I don't have the option to request him to start video. It's showing him as a non-video participant.
That's the best I can do, Your Honor. It won't unmute.
Well, it's not the mute problem, it's the turning the camera on, which it looks like a little camera.
I understand, but it has an X through it and it
Let's go
will
back
not
to
come
the
on.
Let's go back through the history of camels. And you know who Cecil B. DeMille is? He had those cameras.
I
that
do,
he
yeah.
held up and he ran it with his right hand.
Yeah,
There's
I
a
remember
little
that.
icon on there that looks like the camera that Cecil B. DeMille had up there.
Judge, I don't believe he's logged in a way that's going to allow him to turn his video on.
Okay, well, we'll just have to do it without it. And what can I do for you, Mr. Richardson?
I've got a motion to set a trial in this case.
All the discovery finished?
Yeah, you know, we've been to the Court of Apples and back.
Yeah, you got me overturned in it up there, and so I'm ready to go now.
All right.
To be fair, what they said was, they didn't at all say you couldn't do what you did.
They said the order wasn't correct. I just dismissed the case and didn't do a summary judgment. Is that what they said?
And Your Honor, I want to be fair to Mr. Richardson. We've got the same exact problems that we've had for 2 years. We don't have any identification, location of the graves, the number of the graves.
You need to speak up.
We don't have any of we've got the same set of problems that we've had since we started this case. We don't have an identification of the location of the graves, the number of graves, or the area that it encompasses. And, you know, respectfully, Your Honor, I'm going to be bringing the same set of motions that I brought before it was dismissed the first time.
Your Honor, the Court of Appeals said there was ample evidence to prevent the granting of a summary judgment. Now, you don't have to take my word for it. Read the decision. He can bring all the motions he wants. Just give me a trial date.
Concerning you.
Judge, you went off on me. Can't hear you.
Mr. Richardson can be here in person. Mr. Richardson, yeah.
The Zoom cut out for that whole last part. Nobody.
I'm going to reschedule this, Mr. Richardson, so you can be here or have a guardian appointed that can operate that machine for you, one or the other.
Now, if Megan will fix it where I can log in to do that, I will. See, she's said she didn't send it so I could log in to do that, Your Honor.
No, I sent him his the same as everyone else's. It's just for some reason he is showing up as a non.
Well, he's special. He's special.
And Judge,
I'm going to set it for the 24th.
Your Honor, I can't. I'm the 24th. I cannot be there. If you take it to the next month, fine. Am I being heard? Judge, am I being heard?
What kind of?
Now I'm seeing you and can hear you, but you've been going blank for a while. I don't mind to come.
Wait just a second. Go ahead.
I said something with your computer, but she can hear all the time. It's keeping you off for some reason.
Is it up here, you think?
You're working now.
Okay,
Is it working now?
it is. And to tell you, I've not touched anything, so.
Well, congratulations. I hope you can refrain from touching it.
I can't be available the 24th, Your Honor.
Well, Mr. Judge says he can't be here on the 31st. Is that right?
That's correct, Your Honor.
Can you be here on the 28th of April?
Yes, sir.
28th of April.
That'll be fine.
Now, let me tell you, let's revisit what the Court of Appeals said. The Court of Appeals said that I dismissed the case, I believe, and I didn't make any kind of findings that was necessary to do a summary judgment on it. And they also said that your expert witness was an expert.
Your Honor, I don't
I
agree.
didn't read that way.
Well, what did you read about?
What I understood is that
You need to speak up.
Your Honor, we never had a Daubert hearing. A formal Daubert hearing did not occur.
Well, I know they didn't, but they said something about him being an expert. I don't have it here in front of me. Didn't they say something about it?
Yes, Your Honor. And then I took that back up on a petition for rehearing, and then the opinion dealing with the rehearing petition said that would be an issue that the court would have to consider and make findings facts similar to the original decision.
Now, Bobby, what do you think they said about my motion dismissing the case?
They said that there was sufficient evidence to not have a summary judgment granted, that there was sufficient evidence for that. It says it, so we just go back and read it.
I don't have it in front of me right now, and I would just, Mr. Judd, my memory of it was that it said that I inappropriately dismissed the case and didn't make the findings necessary to do a summary judgment.
It also said that, but it also said the other. So
Judge, it even went so far in that opinion to say that it didn't tie your hands. It didn't tie your hands.
read it.
I'll read it again. I don't have it. Megan, do you have a copy of it in my folder? The Court of Appeals opinion?
No.
Okay, could you get that real quick?
Yeah, I'll have to look it up and print it.
Wait a second, Mr. Judd has one. He'll copy his. We'll just go. You got a copy of yours, Bobby?
I have a copy. I don't have it in front of me, but I've got a copy.
Well, get a copy of it in front of you. You need a copy also, or you got an extra copy?
There are two opinions, Your Honor, and I think that is the first one.
This is the one about the summary judgment.
Rendered July 2nd, 2021. That's what I take away.
Wait just a second.
I need Martha now. Judge Judge, I've not been able.
Just wait just a second. I've got it in front of me. I'm reading it. Hold on.
Okay.
Well, it's an odd opinion a little bit in that it finds that I did not hold a hearing on the issue of summary judgment or Mr. Levich's qualifications, but they go ahead and find that it would survive a motion for summary judgment based upon the evidence they have in front of them.
And Your Honor, respectfully, I took that issue back up again.
Yeah.
There is another order on rehearing after that, Your Honor. That's.
Yeah, I got the second. Okay. It still says we are of the opinion that material issues of fact exist that precluded summary judgment, and the circuit court erred by dismissing their complaint. It still says that in the second opinion. Which I don't understand. If they find me in error for not holding a hearing and not granting summary judgment, but they found out that based upon what they know, they already think that there's enough to survive a summary judgment motion. But that's not the order that was up on appeal. I dismissed it partially out of frustration because nobody was taking any evidence that would indicate any seismic or anything that would indicate where those graves were. So I don't think it's ready to set a trial today. I want some more motions on whether Mr. Leftwich is a expert witness or not. And I wanted some more motions on, you know, what he could tell and whether, why has your client ever done any seismic, Mr. Richardson?
They don't have the money and to do that. It's very expensive.
Your Honor, I represent a concrete cutting company
You
out
need
of
to
Franklin.
speak up.
I represent a concrete cutting company out of Franklin, Kentucky. And they use ground penetrating radar on a daily basis in construction projects all throughout the Commonwealth of Kentucky. There are in and around Bowling Green, Kentucky, there are 5 companies that do the ground penetrating radar. It is not that expensive.
Well, why don't you do it then?
Respectfully, it's not my burden of proof, Judge. And
well, if it was mine, it appears to me that a court of appeals wants this to go to trial. If I do a summary judgment on the thing after having a hearing, I think we'll end up back where we are now, because I think they've already decided that a jury ought to try this case. That's what I'm thinking. They've had 2 shots at it, and both of them, they said.
Your Honor, my client is very sympathetic at this point in time. I don't know that we're afraid of a jury trial. So we may come up with a counterclaim at this point.
Well, you haven't filed one yet, so I don't know. Maybe I just ought to set it for a trial and let them lay where Jesus flings them, as my old law professor used to say. But I really don't see how a land surveyor, is he a civil engineer or?
No, Your Honor, Mr. Leftwich is not
I
a
don't
civil
see,
engineer.
I think whatever he says about the location is hearsay. Somebody
Your
else.
Honor,
Yes.
he didn't say there were graves in part of that area. The evidence is of David Arms.
Well, I'm on the issue of what Mr. Leftwich is going to testify to. I know David Arms says that. You know, and I think there was also another lady.
Yes.
Yeah, Ms. Stalkup also. That's not an issue. My issue is what Mr. Leftwich is going to testify to. Now, if he testifies that he's making let me finish here. If Mr. Leftwich is going to testify that he made an illustrative drawing and it has on there what those 2 people told him where those graves were, I don't see a problem with that. Now, if he starts,
that's exactly what he's doing.
But there was some testimony about depressions and other things that he was going to testify to that I don't know whether he's qualified to say that. Go ahead.
This is what he said. He said, I observed an area with little rocks and depressions the size of a grave. And I have included those within here. And David Arms said those and this other area were graves. Mr. Judd asked him about that, and he said, well, all I can tell you is I know what a grave looks like. David Arms said they were graves. I think they're graves.
Mr. Richardson and I are never going to agree that an apple's an apple in this situation. The primary exhibit has what is called a disputed area. And the problem is for him to exceed or this to encumber this piece of property, it has to also take in the shaded area to exceed the proportional amount of acreage for it to be a cause of action under Kentucky law. It's got to be more than 2/10 of an acre of the total of 2 acres that were sold. So it's got to take in this disputed area. In my memory of the testimony is beginning with David Arms is that Mr. Arms testified that he took a stone out there for his mother, but he didn't know where she was buried and he just laid it out there without anybody's permission. There are 3 stones. Now, Mr. Arms' testimony clearly indicates stone number 1 was just laid out there by him. The other 2 stones are in dispute as well because one of the gentlemen that was buried underneath that stone also has a stone in Virginia. So we don't know if he's there or not. So we have one putative stone in an area that would be 2/10 of an acre. And we don't have any proof whatsoever of the fact that there's anything underneath here. Now, what Mr. Leftwich testified to is that he relied upon the parole testimony of David Arms, which couldn't be less accurate than what it is. So, neither one of these persons have any training or education in forensic science of any kind. I ask them those questions. And so, Judge, we really need a Daubert hearing at some point in time, in addition to all these other problems that we've got. The second, and probably the biggest problem that we would bring before the court, or that we believe needs to be addressed, is under the existing case law, the damages in this case are limited to the proportional share of the property that is encumbered versus the whole. So in other words, if the property sold for $40,000, for example, which it did in this case, the damages would be limited to $8,000, which is 20% of the proportional value. Mr. Richardson and I need, one of the things that with the court that we're going to have to ask the court to address is what the law is on the issue of damages. Because so
you say it's a proportionate reduction in the purchase price?
Exactly. That's all he can get.
Said it should void the sale.
Well,
no, I didn't say that.
Well, I'm just asking that. What did you say? Wait,
his damages.
What did you say, Mr. Richardson?
I have an appraisal from Steve Wilson, a before and after appraisal. What was it worth with the cemetery and what was it worth without the cemetery? And that difference between before and after value is what we say we're entitled to.
Well, let me ask you something. So what did your clients pay for the piece of property?
I believe $40,000.
Okay, now what is the appraisal say it's worth?
I think 10. I wasn't prepared to answer.
No, what is the appraisal that Steve Wilson said? It's worth.
I think 10.
Wait. Is it worth more than $40,000?
It is worth 10, is my recollection, Judge.
What's worth 10?
The land afterwards.
Well, so the 20% reduction in the volume of land changed it from being worth $40,000 to $10,000.
That's correct. Based on what Steve Wilson has said.
Well, what did he say it would have been worth if it hadn't been excluded?
$40,000 that they gave fair market value for. Now I've got it in my hands and I can tell you exactly.
Okay.
Just take me a minute to find it.
But Judge, that's not all they're asking for. They're trying to redline and get into incidental and consequential.
Wait just a second.
Well, I'm having trouble finding my. I thought I had the appraisal right here in front of me.
Well, I've got my calendar here. Do you have a calendar in front of you?
I do.
I'm going to do this on some day other than a regular rule day because y'all can't be, I'm not going to put it off for 4 or 5 months here. Let's just pick a date that we'll have a Daubert hearing and then we'll have a hearing about what the law is on what you could recover on the loss of this area. Okay? Those seem to be the 2 remaining issues that we got. Let me pull my calendar up. Megan, what I have set on the 16th
of February, Your Honor.
No, I'm talking to Megan.
That's the Evans versus Pickerel settlement conference.
And that starts at what time?
10 a.m. It's here in Cumberland County.
Yeah. And that will probably last 3 hours or something.
At least.
May I interrupt, Your Honor?
Yes.
I am going to be out of town from the 12th to the 26th of February.
Okay. Megan, on the 28th, I have a hearing scheduled. Where is that and what is it?
That is the hearing where you're going to interview the thrall child in the custody case, but you.
Okay, so that won't take that long.
Oh, but you have me in discussions. You needed to move that. I'm in discussions of moving that right now.
Okay, well, I'll remove it. Okay, that's correct. I remember that now. What does the 22nd of March look like for you guys?
I can do it. I can do it if it's in the afternoons, no problem.
Can you be here then?
I'm open, Your Honor.
Okay, let's start it at 1 o'clock. And I want to do this in person, and I want y'all to provide me briefs on the issue of the Daubert, why why this gentleman, what do you think he can testify to, what he can't testify to, if he's an expert. And the other issue is to define what damages under the law, and give me some case law, what damages under law someone is entitled to if they find that there's a reduction, the size of this reduction and the size of this lot.
Yes, sir.
And those will be the two issues that we have. And I guess you can file a motion for summary judgment if you want to for that same date. And then I'll reread these two opinions. I don't think the two opinions change that much. I don't see that much difference between the two opinions. What do you think is the difference, Mr. Judge, between the two opinions?
Your Honor, there's the law of the case as it's presented. But my understanding of summary judgment proceedings have been.
I'm talking about these two opinions.
Right. But Your Honor, the two opinions to me, really, to be candid, aren't binding on this court in any shape, form, or fashion.
What's the difference between the two?
The second opinion that the primary issue that I took up to the Court of Appeals for rehearing was the fact that the purported survey was neither stamped nor signed by Mr. Leftwich. And they consistently called that a survey in the first opinion. I wanted to make it clear to everybody involved that that's not a survey, predominantly.
That's the reason I use the term illustrated plat or something like that.
Yes, Your Honor.
Okay, well, I don't think that's going to be an issue, so. Okay, on the 22nd, starting at 1 p.m. Okay?
Yes, sir.
And
Thank you, Your Honor.
And can y'all get me the briefs maybe by the 8th of March? On those-
No problem here.
Okay, thank you
Yes, Your
very
Honor.
much. Y'all have a great day. Bye.
Thank you, Judge.
In Grubb versus Grubb, there is a agreed order on Turner versus Bernard.
Good afternoon, Your Honor. We'll try to be a little bit quicker for you.
Oh, you're going to announce the settlement?
No,
That's up to him.
We can tell the court this case does not involve a cemetery.
Yeah. Yeah.
Yeah.
So don't whistle by it, whistle by the cemetery. What is this case about?
This is regarding a motor vehicle wreck, Your Honor.
A what?
A motor vehicle wreck. At this stage, discovery's been completed for the, we've moved through 2 depositions already of the plaintiff and 1 physician. We're expecting 2 more depositions to still be needed, 1 of the defendant and 1 of another physician. So at this stage, we're just hoping to go ahead and set a date for trial, preferably if possible, mid to late October.
And you get one a lot sooner than that if you want one, if you'll finish the discovery. All I'm gonna ask you to do is finish the discovery. You don't have to come back here, get me on the phone with my staff lawyer. Is it 2-day trial?
Yes, Your Honor.
Okay, and have you gone to mediation on this at all?
We have not, Your Honor, and, but it's been discussed, but I can tell you at the moment, we are actively negotiating and trying to get the case resolved.
Would it help if I ordered mediation?
I would say give us a little more time, because I'm not certain we need it, Your Honor. And obviously, if it gets to that point, then we'll absolutely let the court know.
Okay, well, what I'm gonna do is, I don't want you to have to come down here on this thing. Well, y'all work on it. If you don't have it settled in a month from now, y'all get us together on the phone. We'll go on the record. I'll order mediation if you don't have it settled in a month. And then after the mediation, have your discovery finished, we can set a trial. And usually after you get February and March out of the way, there aren't a lot of conflicts after that. There's a lot of people moving around. You really don't want to have people sitting here on the jury pool while the NCAA tournament or the SEC. I mean, you have a bunch of mad jurors, so.
That's a great point. No, I think all of it.
And a disgruntled judge, so.
I think all that sounds good, Your Honor.
So we can get you something even in July, even in June. Of course, you'll need some upfront time to schedule. Are you going to present your doctor's proof by video, or are they going to appear here live, or what are you going to do with that?
From where our planning so far, it will be video.
Okay.
The first one's already been taken by video. Second one was set up by video in December and had to be rescheduled. But
Okay.
I think that's a great idea. You're going to give us 30 days.
Okay.
We'll report back to the court.
Okay. Okay. Well, that's a great thing then. Okay. Okay.
Thank you, sir.
Thank you very much, Your Honor.
Okay. Have a great day.
You too.
Right versus right. She's what?
And she reported her assessment. Was just making sure that everything was secure.
Well, yeah, so this thing with right versus right, they didn't file a motion to reconsider that, and that's what this was, to set this date out to see if they wanted to object to that, and they haven't filed anything. Okay, does that conclude the civil docket?
It is, there is adoption.
Okay, well, that concludes the public portion. We have some